Oh, hi. I'm Bob Motta. This is Defense Diaries, and I am now joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
Hey, what's up, y'all? It's been a minute. What, Friday? Go live Friday? I can't remember.
What is this our continuing coverage of?
This is our continuing coverage of the Commonwealth of Massachusetts versus Brian Walsh. So if y'all will recollect, I think it was a couple of weeks ago, we went through the defense's motions to suppress. They had a couple of them. I think we went through one very thoroughly, and then I think we skimmed through the second one, if I remember correctly. There was one that was of great import, which was the warrant relating to the Google searches, which we find all the damning evidence of these bizarre, seemingly very inculpatory Google searches made by somebody in the Walsh household on their 6-year-old's iPad. Seeing that nobody has seen Anna Walsh, the victim in this case, since the 31st of December, and the searches took place, some preceding, but many on New Year's Eve day, would stand to reason that it was probably Brian Walsh. So at any rate, the defense said, hey, you know what? There was an agreement and consent search of the devices. However, we didn't consent to you guys looking into everything, in particular, browser data in terms of.
Right. They claimed it was limited to the text messages and conversations.
Right. Excluding him and his attorney. So him and his attorney were verboten. So the defense is saying it was very narrow in scope. The cops are saying, they didn't say that to us. The only
Who
thing
testified about that again?
Bukhenik.
So Bukhenik testified, no. It was everything, every possible thing that I could search could be searched, except text messages with his lawyer. And again, as Bob described, the defense is saying, no. We only agreed that you could go through text messages, and then we limited the scope of the text messages we were allowing you to review.
Yes.
And the judge, it was a credibility determination. Does she believe the lawyer for the defense who says that that's what it was limited to? Or does she believe the very credible, very respected Bukhenik?
And Proctor.
And
all right. So for
of
those
the utmost integrity they are. Why not believe them?
Oozing with integrity.
Oozing with integrity.
Oozing. So for those of you who are not familiar with the case, our beautiful and brilliant Tracy has put together over at Seeking Justice, put together some awesome timelines. Just to give a very brief overview of the case, if you don't know anything about it, Anna Walsh sadly went missing on December 31st of 2022. And this is kind of what led up to it. She's a mother of 3. They had 3 boys. They've never found the remains. It's a tragic case. Another case that very much seems like, what about a divorce?
Right. At first, they didn't find the remains, you mean?
Yeah, it's sad. So this is just kind of a quick overview, just for those of you who may not be at all familiar with the case. Anna and Brian in 2013 began dating. In 2015, Anna and Brian got married. In 2016 of July, their first son, Thomas, is born. In 2018, September, Brian's father, Dr. Thomas Walsh, dies and leaves nothing to Brian. In October of the same year, 2018, Brian is arrested for selling fake Andy Warhol paintings. In 2021, April, Walsh pleads guilty to 3 of the 4 counts in exchange of selling fake Warhols, in exchange for a recommended sentence of incarceration, supervised release, fines, restitution, and forfeiture. Fast forward to 2022. In February, Anna begins her role as a regional general manager at Tishman Speyer in Washington, D.C. In March, she sells the family home on Jerusalem Road in Cohasset for $1.385 million. March 18th, Anna closes on the purchase of a townhouse in Chevy Chase, D.C. in the 1.3 million range. So there goes that cash. In November, Anna Walsh was having an affair with a man in DC and spent Thanksgiving with him in Dublin. December 27th, Brian Walsh began Google searches. December 30th, Anna flew home to Massachusetts to be with her family for the holiday weekend. December 31st, Brian and Anna Walsh hosted a New Year's Eve dinner with a friend named Jem. And thereafter, Anna Walsh is never seen again. So that's kind of just a very brief, basic background of this case. And
when they do eventually find her body, they find evidence of, is it horse tranquilizers or?
Wrong woman, wrong case.
Oh, what?
That's Morphew. You're thinking Morphew.
Oh, that's Morphew. My Lord, I can't keep them all straight.
You're so cute.
I cannot keep them all, the murdering husbands, straight. All the men too afraid to get a divorce.
It's a challenging task.
I mean, murder is so much easier. It makes so much more sense. Everyone's doing it, and I can't keep track of who's who. So, all right. So wait, they never did find this woman's body?
No, ma'am.
Aw.
No,
so they okay, so that's right. All right. I'm with you now. It was the searches.
Yeah.
It was the searches.
Morphew was just recently rearrested. And that was the tranquilizer.
Right. Okay. All right.
For deer.
Strike that from the record, counsel.
I'm going to keep that in perpetuity on this live so that you have to live with that shame. Shame.
That's why when you said that they never found her body, I was like, oh, but then they did find the body, because I was still
you had no problem trying to throw me under the bus. So
I was like, this man's just got it all wrong.
Right,
what is he doing?
Up all the facts. Sometimes those kind of little takedowns just turn right around and bite you in the ass, don't they?
Yes, they do.
Indeed, they do. All right.
Perimenopause brain.
I wish I had that kind of excuse built in. It's pretty good. It's pretty. I mean, I cannot for 1 second deny that it's real, because it is so real. It's like sometimes I feel like I'm walking around with like an 85-year-old woman who's forgotten everything that she's once known. It's like, it freaks me out, really, truly. I'm like, babe, I'm talking like some basic shit. Like, and I'm like, what is going on? She's like, dude, shut up. She's resorted to having to put this giant airplane fan in front. She's like, Bob, last night, I'm like, babe, I can't hear this. She's like, Bob, shut up. I'm about to take care of myself. I'm putting this fan in front of the bed. I don't want to hear it. I'm like, all right.
I'm freezing, then I'm hot, then I'm freezing, then I'm hot.
Yeah, it's a real thing. So we're like, I forget who suggested someone on our
we haven't purchased it yet.
It was followed up by our friends the day after, or a couple days within, somebody in our chat saying to get what's it called? The bed stream?
Something like that.
Bed jet. Like our friends, like, oh, she's like, we just got this thing called a bed jet, and it's the greatest thing ever invented. It's incredible. So Allie's been on me. I got to get my woman a bed jet. I have to get her a bed jet.
Yeah.
Otherwise, I fear she may divorce me. Just because I refuse to make her cool.
Never.
All right.
So anyway, the judge took a long time to rule on these motions, and we thought, is it possible that she was going to find a violation? But again, it came down to credibility, and you have again, very credible Bukhenik working with the very credible Proctor.
Yeah.
And someone else, what was his name? Fanning.
Yeah. So look, combined, now this is not Judge Gull. So this judge writes very thorough, detailed opinions and memorandums of law when she makes a ruling. So these are both 31 pages. Well, 31 and 36 respectively. So I think I lied to Allie and said they were both like 31, because I know how she gets with long documents.
No, I opened them up. I looked at those. I saw it.
Foiled. So the fact pattern is different, but the same in terms of like both of her memos. We'll take it as it comes in terms of like deciding that we can skim
Right, and
over
the reason the fact pattern is important because that tells you the facts as the judge has decided to believe at this point in time, you know?
Yes, exactly. I mean, she's adopted the cops and the prosecutor's facts, so that's it.
And when a judge judges credibility, it's the hardest thing to appeal because that's the way the law works. They say, the trial judge had the benefit of observing the people testify and
I don't know. I don't know if you can change. I don't know if it's always cooling or if it's
no, I think it might do both.
oof. The last thing I want is hot air being blown into my
Yeah.
bed ever. I
Never.
don't give a shit when it is.
I
There's
guess if
no
our
time.
heat goes out for 2 weeks.
Okay, if our heat goes out, we're getting an Airbnb. Like we tried to power through and did power through the air conditioning nightmare. A heat thing, this house would be like 50 degrees. It would be brutal. I don't know. Maybe we could power through. Should I?
We could snuggle.
Oh, lots of snuggle times. Snuggles. All right. So a couple of announcements before. Really excited. We're really, really excited. Wednesday night, 6 p.m. Central Standard Time. The one, the only, the lawyer extraordinaire of the Karen Reed defense team, Bob Alessi, will be joining us. Solo. David Yannetti is going to be joining us. It looks like the first week in August. He's on vacation this week. And then he has a brief trial in the very beginning of August. He thinks it's going to be a one-dayer, and then David will join us. So originally when I talked to Bob today, we decided, we're like, well, it's up to you guys. Do you guys prefer doing them together? Do you care doing them alone? And like, I ended the phone call with them, with us saying, you know what, we'll just wait till Dave's ready and we'll do it with you guys together.
Babe, did your ex get hacked?
What are you talking about? Why do you say that?
I don't know. Let's talk about somebody else. Oh, maybe they're talking about Bob Alessi.
Oh, yeah.
Sorry.
Nobody's hacking my ex. I'll sniff you out. You get sniffed out, you mess with my ex. So, I asked Tracy and Mandy, I'm like, what do you guys think? Should we do it solo? Should we do it together? Allie's like, well, we have all these great questions and, we'll have to rewrite new questions if we do them. And then I'm like, you know what? I think it would be cool to do it because they seem to, I've seen a couple random where David was on one without Bob. And I don't know if I've seen any with Bob without David, but I think for the purposes of three of us, I like the solo venture.
Yeah. And I think that was a good call because there's already two of us.
Right.
So
four's a lot. Four's a lot. And we've gotten much better over the year and a half, 2 years in terms of not talking over one another.
Keeping Bob from not talking. Keeping me from not talking over and keeping Bob from not talking.
That's still a problem. That's still a real issue. But I'm excited about it. So mark your calendars. Mandy's furiously working on a thumbnail because I want to promote it. So let your friends, let your neighbors know. It should be a good interview. I can guarantee you we're not going to ask the same questions that everybody else asks. That's not what we do here. We know they've done a bunch of interviews. So,
and then Bob, just because Kyle just mentioned it, and I saw someone early before we even started the live said, thinking of you in Manhattan or something to that effect. So I looked it up and there was a shooting in Manhattan.
There was one in Vegas today too at a casino. Oh no, I'm sorry. In Reno, Nevada, in a casino. Apparently there was another mass shooting last night in Atlanta. I saw Josh, our friend of the show, Josh Schiffer, posted about it that 11 people. I don't know if there were any fatalities or people were injured.
And literally all I saw, because when I saw Rachel Johnson's comment for Manhattan, I just Googled news Manhattan and saw reports of shots fired in Midtown Manhattan.
Yeah, I mean, kind of the spirit of Josh's post was this is becoming so commonplace that people aren't even talking about it. Like the news is barely reporting on it. I mean, obviously, Manhattan, that's going to get some publicity. Wow, 6 fatalities in Manhattan, including police. Jesus, what is wrong with people? You know what? I'm telling you, it's this shit. It's these things. It's these devices. It's like we're all like it's fucking with our brain waves. I'm telling you.
People are just getting all worked up about everything.
It's so much. It's so much. I don't understand it. Well, our hearts and thoughts go out to all the people that were injured and or killed in these senseless attacks that just I've never seen one where like somebody was like, oh yeah, like this is like why I decided to shoot up a school or a business, and thought, wow, well, yeah, that's a really legitimate reason for
How
doing
could that ever happen?
I never felt like that. Well, like what happens if it's like a business that's making like some kind of
right. So you're saying that at least they even have a rationale
or some shit, and they're like, who knows? I mean, point being, there's no excuse for it, really, ever. It's like there is no valid excuse for it. It's so sad. It's so sad. And it's not to say that it doesn't happen in other countries, but because it does. But the level and occurrence rate of it in the United States is shocking. It's shocking. It's like we have, oh, good. Travis is throwing some facts up here. So Travis says in 2024, there were 503 mass shootings in the U.S., resulting in 1,694 fatalities and 4,322 injuries. Wow. It's unbelievable. That's crazy. It's crazy. It's like, and I am not anti-Second Amendment at all. But I understand that the reason we need it is in case the government gets like a little out of hand.
Yeah.
We need to arm ourselves.
We need to stand up. We need to rise up.
Right. I mean, which was the actual reason in terms of why the drafters put the Second Amendment in there. That was why. But it's been bastardized, and it's like just some of these weapons that people use in terms of semi-automatic and like AKs and all these like death machines. I don't understand it. I don't understand it. It's like it's crazy. I mean, are these people that are doing these things any different than Brian Kohberger? I mean, it's like the same amount of planning and, just sitting there obsessing about doing this thing. And you're like, what?
That's a different level of,
I don't know that it is.
It's just I don't know, different level of beast, just like the shooting from a distance and like creeping in people's house and slaughtering them with their hands.
Like somebody walking into just a business or a school. I don't know that it's a different beast at all.
School, no, stop.
I would disagree.
All right, so
same beast.
Camilla says, turning back to this case, this is a tough case. It doesn't look good for him, Brian Walsh. Still pissed about Massachusetts State Police shit show. Yeah, well, let's see what the judge did here. And this is all, an academic discussion, because at the end of the day, the judge ruled the way she ruled, and, right or wrong from a legal perspective, or from a who she should have found credible perspective, don't take us dissecting the motions and the Constitution as being in support of Brian Walsh, because
I mean, the last thing that you want is the cops fucking up this case. So I was talking about that when we did our last live. I'm not rooting for these knuckleheads that fucked up Karen Reed's investigation in that case and caused all this bullshit to do the same thing here, because this guy, in my estimation, very much seems like the perpetrator. And it would be awfully horrible if he walked because the cops fucked it up.
Presumed innocent, and we shall see. But on the face of what we know, there's a lot that points to guilt.
Indeed. Do you want to kind of share reading? We'll split reading. Does that sound
Ruling
fun to
on
you?
paper. What does it say? 8301. Well, I'll look at it on my own screen if you'll move. Okay. So memorandum of decision and order on defendant's motion to suppress search warrants, ruling on paper number 83.01. The defendant, Brian Walsh, has been charged with 1 count of murder, 1 count of misleading a police officer, and 1 count of unlawful conveyance of a human body. He moves this court to suppress evidence against him obtained during the execution of 13 search warrants by Massachusetts State Police, arguing the warrants were not supported by probable cause and were impermissibly broad. So this is the one we're starting with. Is the other one deals with the consent issue?
Yeah. In this one, the reason I kind of wanted to start with it because I thought it made more sense. She references the other one in this particular opinion and memorandum.
Okay.
So like this one dealt with a bulk of the motions. That one dealt specifically with the motion with respect to the search of the iPad and the phone. So, and the warrant that they sought thereafter. And in this, it makes more sense because she allows us in part, meaning she granted some of it and denied some of it. So there's certain things that she grants and certain things that she
All right.
denies.
So moving on. On
So I
June
think you can skip like the warrants.
Okay.
Yeah, there's 13 of them challenged.
On June 18, 2025, the court held a non-evidentiary hearing on the motion. After careful review of the warrants at issue and the arguments of the parties, the court concludes that there was probable cause to support the search warrants for the defendant's residence and electronic devices, but not for the GPS tracking of his mother's Volkswagen, and for some, but not all, of the records sought from his cellular phone provider. For those reasons, the motion is suppressed. The motion to suppress is allowed in part and denied in part.
Okay.
So, background: there are 13 warrants challenged here. She lists the 13 warrants. The one for his residence, the one for the Volkswagen, the one for a MacBook, 2 MacBooks, identified by
phones, iPads, all kinds of shit.
the Apple iPad 6 mini, the red iPhone warrant, another MacBook, a black iPhone warrant, an iPad 6 warrant, Verizon warrant, two Verizon warrants, and another iPad warrant. The court's inquiry as to the sufficiency of search warrant applications always begins and ends with the 4 corners of the affidavit. So for those, that's why you have a non-evidentiary hearing. All they look at is the affidavit. When they say the 4 corners, it's what's written on paper. That's it. She doesn't consider anything outside of that. The facts pertinent to the affidavit at issue are as follows. 1, the Walsh residence warrant. MSP Trooper Michael Proctor submitted the application for the Walsh residence warrant. Trooper Proctor has 10 years experience as a police officer and is assigned to the State Police Detective Unit at the Norfolk County District Attorney's Office. Should it say was?
Yes.
Okay. Oh, wait. There's a footnote.
Footy.
It says, although the court is aware that Trooper Proctor is no longer part of the MSP, its recitation of the factual background is as stated in the affidavit supporting the warrant, and its inquiry into the sufficiency of the affidavits is necessary based on that recitation. Okay. Or recitation.
Yeah. An inquiry.
And then there was a footnote 1 earlier that said police obtained several other warrants during their investigation, which are not challenged by the defendant. The defendant's motion, that's the other one, 8.83.0, states he challenges 2 additional search warrants. However, at hearing on the motion, the defendant clarified that he was only challenging the above noted 13 warrants. Okay. He, Proctor, has extensive experience investigating violent crimes and collecting crime scene evidence, and is specifically trained in cellular telephone data and call records.
Is
u-
he? Is he really?
So he claims on the
Are we
four
talking
corners,
about the same cop?
right? The four corners of his affidavit says so.
Wow.
And call records used in support of criminal investigations. The Quincy District Court issued the warrant on January 8th, 2023, footnote 3. Trooper Proctor wrote the incorrect date of submission, surprise, surprise, on the Walsh residence warrant affidavit, stating that he submitted it on February 9th, 2023. The defendant does not argue, nor does this court find that such an error should factor into the analysis of this motion. Cite a Commonwealth case that typographical errors are at most negligent misrepresentations and cannot form the basis of suppression. Returning to the body, the warrant sought A, physiological evidence including hair, skin, blood, brain matter, bodily fluids, bone, and any other items that may contain their presence. B, electronic devices including cell phones, iPads, laptops, and other devices capable of communication, custody and control, internet searches, recording, or video surveillance. C, clothing and jewelry described to be worn by Anna. D, Anna's passport, wallet, and cell phone. And E, instruments of the crime, including blunt force objects such as a hammer, knife, hacksaw, trash bags, cleaning supplies, and receipts or such items, or probably should be for such items, and financial documents indicating their purchase. Sorry. Police executed the warrant on January 8th and 9th of 2023. The affidavit supporting the Walsh residence warrant provides the following information. On January 5th, 2023, at approximately 3:45, Cohasset police notified state police detective
Cohasset or Cohasset? Let us know. I forget. It's been long. So you guys you schooled us last time. I can't remember which one's right.
State police detectives assigned to the NCDAO of a missing person and requested assistance. Cohasset police reported that the day before they responded to 516 Chief Justice Cushing Highway, the Walsh residence, after receiving a call from Hugh Dunleavy, the head of security of Tishman Spidey in Washington, D.C., the employer of Anna Walsh, stating that she had not been seen since December 30th, 2022. Anna split her time between Massachusetts and Washington, D.C., maintaining a residence in D.C. for work, over $1 million residence in D.C. for work, and one in Cohasset with her husband, Brian, and their 3 children. Dunleavy told Cohasset police that Anna's vehicle was presently at her Washington, D.C. residence. Cohasset police officer Gregory Lawrence went to the Walsh residence on January 4th, 2023. Brian was at the house. Brian stated that his wife Anna was missing and that he wanted to file a missing person report. What? Oh, now you want to file a report when they come knocking on your door? What? According to Brian, Anna had left the Walsh residence between 6 a.m. and 7 a.m. on January 1st, 2023, taking a Lyft or an Uber to Logan Airport in Boston to return to Washington, D.C. for work. Brian had no specific flight information. He explained that despite efforts to reach her, he had not spoken to Anna since the early morning hours of January 1st, 2023. Brian had not contacted the police, but only Anna's employer, who in turn notified Cohasset police. Cohasset police requested and were granted a ping for Anna's cellular phone from Verizon. Cohasset police received data from Verizon at approximately 3:30 p.m. on January 4th, 2023, indicating that Anna's phone pinged in the area of Reservoir Road in Cohasset, which encompassed the Walsh residence. The data further indicated that Anna's phone was stationary starting from the evening of December 31st, 2022 until 3:45 a.m. on January 2nd, 2023, at which time the phone went off and did not turn back on. Washington, D.C. Metro Police performed a well-being check on Anna at her DC residence. There was no sign of Anna. There was no indication of any foul play. Further review of Anna's employment records, including her access to the employer's building, video surveillance of the parking garage, corporate credit card transactions, and phone and email activity, showed no indication of any activity by Anna on January 1st, 2023, or any time thereafter. Cohasset police checked domestic and international flight records and found no indication that Anna had booked any travel on January 1st, 2023. Anna had booked a flight from Boston to Washington, D.C. on January 3rd, 2023, but she did not board the flight. Cohasset police also requested records from Lyft and Uber. They had no records related to the Walsh residence or Anna's account on the relevant dates. Anna's financial records did not show any activity on January 1st, 2023, or any time thereafter. Thank you for repeating that, Your Honor. Police entered Anna into the National Crime Information Center, also known as the NCIC database, as a missing/endangered person on January 4th, 2023. On January 5th, 2023, investigators from various agencies canvassed the vicinity of the Walsh residence and conducted numerous interviews. On January 6th and 7th, 2023, law enforcement conducted large-scale search and rescue operations in the area of the Walsh residence. The searches did not produce any evidence. On January 6, 2023, at 8:30 p.m., Cohasset Police Detective Schmidt and MSP Trooper DeChico interviewed Jem
Mutlu.
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 Going Mutlu.
Mutlu.
Mutlu had been at the Walsh residence on December 31st of 2022. He stated that he arrived at the residence at approximately 8:30 p.m. and had dinner, champagne, and wine with Brian and Anna. No other adults were present. According to Mutlu,
Let's call him Jem. Jem's easier.
Okay. According to Jem, everyone was enjoying themselves and in a good mood. He left the Walsh residence around 1 a.m. to return home.
Sounds like Brian was faking.
On January 6, 2023, Brian's attorney, Tracy Minor, provided verbal and written consent to turn over Brian's cellular phone and 2 Apple iPads.
Footnote time. It's footnote time. Everybody loves a footnote.
Okay, babe. The affidavit did not provide any information about the cell phone, such as a phone number or its make/model, or any further information about the Apple iPads. Returning to the body, MSP Lieutenant Fanning secured all 3 devices, which MSP forensically extracted at the NCDAO and returned to Brian the following day. Footnote 5. The information obtained from these devices is subject to another motion to suppress. See docket number 78, motion to suppress information resulting from search of electronic devices based on consent. Because the court has denied that motion, maybe we should have started there, babe. The information obtained from the consented to searches is properly considered as part of the affidavit supporting the search warrant.
You glitched out.
I did?
Yeah, a little glitcher. Little bit of a glitcher right there. I noticed it. I don't know if it was on the live though.
All right. So basically what we're saying here is, like, had she granted that motion, the ruling on this motion would have been very different because they wouldn't have had any of that evidence to rely on. And
Fruit of the poisonous tree.
And that was the fear that MSP's Bukhenik would have resulted in, in evidence getting tossed. But
wow, you just went there.
Yeah,
you just completely went there.
All right, returning to the body. Actually, that's all right. On January 7th, Detective Schmidt and Trooper.
Oh, sorry.
Now I forgot how to say his name.
Bukhenik?
No,
Bukhenik.
DeCicco.
DeCicco.
Hey, and troopers DeCicco and Proctor interviewed Brian at 1:30 p.m. at the Walsh residence. Attorney Minor was present for the interview. Brian stated that on December 31st, 2022, Anna told Brian that she had to fly back to D.C. first thing in the morning, which surprised him. According to Brian, at approximately 6 a.m. on January 1st, 2023, Anna, who was preparing to leave, gave Brian a kiss goodbye and told him to stay in bed since he had to get up with the children soon. Anna was wearing a thin black coat, blue-gray hunter rain boots, and a black floral dress. Around 6:30 a.m., Brian and Anna's oldest child was awake and had asked Anna to fix his iPad. Later that day, around 2:30 p.m., the Walsh's nanny arrived. Shortly after 3 p.m., Brian left the Walsh residence and went to Shaw's supermarket to purchase milk and orange juice. I'd be interested to know, and I don't know, maybe somebody already knows, who requested the nanny to come that day.
I mean, it seems like the nanny might be like a daily thing during the week, right?
Yeah, but would she need to be? Both parents were there.
I don't know. I mean,
guess
why
that'll
would
be something we'll
Brian
have to
call
find
the
out.
nanny? Like, why would he want the nanny there?
Well, maybe if he's alone and it's just him, he has a nanny come help.
I
When
mean, because there's
mom's
definitely
not there.
no school anyway on January 1st.
What if he works from home?
Yeah, but I mean, nobody's doing work on New Year's Eve day, theoretically.
Yeah, maybe he's just well, he's got to go supermarket, da 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 da. I don't know. It'd just be interesting to know was she scheduled to come or was she specifically asked to come, and if she was specifically asked by whom and when.
Yeah.
Okay, returning to the body.
Moving on.
Moving on. He returned home, placed the groceries in the fridge, and left again around 4 p.m. to head to his mother's residence in Swampscott. The ride took longer than usual because Brian got lost. Normally, he would use his cell phone GPS for directions, but one of his children had taken his phone on December 31st, 2022, and he did not find it until January 2nd, 2023. He did not know how to use the Volvo's GPS. Brian stated that he took Route 3 north to Route 93 north to Route 1 north. Then he took Route 114 to his mother's house. Brian arrived at his mother's house around 5:30 p.m. and stayed for approximately 15 minutes. He then went to Swampscott Whole Foods where he purchased frozen foods for his mother, and the CVS in Swampscott where he purchased alcohol wipes for his mother. He returned home at 8 p.m. MSP Trooper, what's his name?
Kutkowski.
MSP Trooper Kutkowski reviewed video at the Swampscott and Salem CVS stores from 4:40 p.m. through 8:30 p.m. He did not observe Brian enter the stores, and neither CVS,
because they went to both,
had a record for neither CVS had a record for purchase of alcohol wipes on January 1st, 2023 during that time frame. Video footage from the swamp.
Maybe he shoplifted him.
Video footage from Swampscott Whole Foods also did not show Brian enter the store, and neither his Chase nor Fidelity credit card showed any purchase at Whole Foods. Uh-oh, Brian.
Ruh-roh.
Not on either one. I mean, that one's
Ruh-roh.
That's hard to get around.
That's easy. Like, you know what? I was feeling a little shoplifty that day. So
no, I mean the first store, what was it again? CVS.
CVS and Whole Foods.
Maybe CVS's cameras aren't, as effective. But now you got Whole Foods. Whole Foods. A lot of CVS's have that thing where they track you as soon as you walk in the door. It's like, but it depends. Depends where you're at.
All up in your shit.
All up in your shit.
Yeah.
All right. During the January 7th, 2023 interview, police questioned Brian about why he did not contact law enforcement about Anna being missing. He said that his phone went missing on December 31st,
Hmm.
2022, and then he emailed his mother and business
Likely story, pal. Likely story. Oh, my phone went missing.
the
Yeah, get the
next
fuck
day
out of here.
showing that it
Kidding
did.
me?
All things are possible. His phone could have gone missing, but can't shop at 2 stores that don't have any record of you.
You shop there? Yeah.
Right.
Well, unless you shoplift. Maybe he's really good at
But
shoplifting.
not if they've got cameras at the doors.
Maybe he's invisible. Maybe he has an invisibility cloak and he puts that on.
I
Creeps
mean,
through.
could have had on a hat. Who knows? Who knows? His
No.
lawyers have to go through that and find him on the video.
They're gonna have to go through.
Yeah. According to Brian, he found his phone in his 6-year-old son's bed on January 2nd, 2023. That one's not too outrageous. That one's easily believed.
Maybe for you.
It's the combination of things. It's the combination of things. I also cannot use I tried it the other day. Cannot use the GPS. And if the Volkswagen, also German, is like the Audi, you can't even type anything in. You've got to write it in with your finger.
You can
and
use
it's
the voice.
bizarre. It never works.
Trust the little voice guy.
Doesn't work.
Oh, it works. Works just
No, not for me and Mr. Walsh.
okay. A couple peas in a pod, you are.
According to Brian, he found his phone in his 6-year-old son's bed on January 2nd, 2023. That day, he sent Anna multiple messages stating that he was worried and asking where she was on January 2nd. So they don't have a house phone, it sounds like.
Probably
So
not. We don't
how,
either.
this begs the question, why are you worried? Well, I guess if he gets his phone and there's no missed calls from her, then he can be worried. But I don't know why he'd be worried before, because he wouldn't know that she didn't call because he didn't have his phone.
If I didn't hear from you for...
But he didn't know he didn't hear from her. So why is he sending emails concerned? Right?
I guess.
He said he sent, before he found his phone, he sent an email to his mother and his business partner. And he sent some kind of email to her employer, like asking about her, but then he says he did
This
not.
guy, it says they went to 2 CVSs. Not one.
Oh,
What
did I say?
No, Sky's saying they went to the wrong CVS. Somebody was saying that on the last one. It sounds like they went to 2 of them. So, like in the area where he claims that he was. So I don't know.
Yeah, he said CVS stores at the Swampscott and the Salem.
Yep. Couple of CBSs. And we were just in Salem.
Yes, we were.
And I could tell you, I was talking shit about how he wouldn't know how to get to his mom's place. And people are like, she just moved there. I'm like, yeah, I mean, if you're not familiar with that area, I could see getting lost. Some curvy ass roads. It's like Pennsylvania. It's like, could you imagine trying to
not all a grid, Bay.
Could you imagine finding your parents' home, like your house where they live in like Maryland, without a map, without GPS? Like,
I could get as close as University of Delaware and be like, I know I'm in the general vicinity now. Right. That's still 20 minutes away.
Yeah.
So then this goes on to say that according to Brian, he found his phone in the bed. That day, he sent multiple messages that he was worried and asking where she was. On January 2nd and 3rd, he texted family and friends asking if they had heard from Anna. Brian said he did not become concerned about Anna until January 2nd, which would have been when he found his phone. So I thought he sent some email to her employer before he had his phone. Maybe I'm wrong. Recently, Anna had been unreachable for about 24 hours when she was coming home for Christmas. When Brian had told her that he had been concerned and almost called her work to ask about her whereabouts, Anna had instructed him not to worry and that she did not want any issues at her workplace. For this reason, Brian had not reported Anna missing until Cohasset police arrived at the Walsh residence on January 4th of 2023. Oh, come on. Because that's not 2 days that she was missing, because the first 2 days you just didn't know about it in
Okay, so
theory.
I just Googled real quick. Despite the look on my face, you're still talking. There's one CVS in Swampscott. Takes just a quick Google search. So while there may be CVS's all over New England, there's only one in Swampscott.
Well, they
And I'm
also checked the
imagining
one
there's
in
only one
Salem.
in Salem. So I don't know
I
that
mean,
they
if he
followed
went somewhere else, he's going to tell his lawyer, and his lawyer's going to have
Yeah.
that.
And they
Boom,
still
at
won't have the
trial.
footage because he was dumping her body all over the place. That's
Oh,
what he's doing.
stop. Her body wasn't found. Wait.
Right.
Now you're mixing up two
They've
people.
never found it. I'm just saying
Right.
he's disposed of. What do you mean? I'm not mixing shit up.
Oh,
Right?
I was thinking of how he
Yeah,
went.
there's one in Salem as well. It's a quick Google search.
I was thinking about how that other guy went from
Death
place
of
to place
the
to place.
barroom debate. Google.
All right. MSP troopers Nicholas Guarino and Connor Keefe conducted a forensic review of data extracted from the iPad mini that Brian had given to Lieutenant Fanning. On January 1st, 2023, Brian's cell phone was manually unlocked. The password for the phone was entered at 7:57 a.m., 11:24 a.m., 12:39 a.m., and 12:46 a.m. The forensic review revealed the following internet searches. And then we've got a footnote 6. It's unclear from the affidavit whether the internet searches were extracted from the cell phone or the iPad mini. Later warrant affidavits written by Trooper Guarino clarify that police extracted the internet searches from the iPad mini, which Brian said belongs to his 6-year-old son. So the first search, January 27, 2023, footnote saying that was incorrect date, and it occurred December 27, 2022. At 9:54:13 p.m., best state to divorce for a man, January 1st, 4:55. How long before a body starts to smell?
Oops.
January 1st at 4. Immediately thereafter, how to stop a body from decomposing.
Oh boy.
20 minutes later, how to embalm a body.
Oh my God.
27 minutes later, 10 ways to dispose of a dead body if you really needed to, question mark. 45 minutes later, how long for someone to be missing to inheritance?
Oops.
It's only been a couple hours, buddy. Slow down. January, okay, and then 10 minutes later.
Wait, he didn't even know she was missing then.
Nah.
Thought she was fine. She's at work.
She's at work. She just left for the airport.
She
hadn't even left for the airport yet.
Flying to DC to bang her boyfriend.
All right. 6:33 a.m. Cohasset dump. A minute later, 30 seconds later, Hingman dump. 50 seconds later, can you throw away body parts?
Hingham.
Can you throw away body parts? 3 hours later. What does formaldehyde do? Okay. 5 minutes after that. How long does DNA last?
What's up, T?
About 20 minutes after that. Can identification be made on partial human remains? A couple hours later, dismemberment and the best ways to dispose of a body.
Oops.
10 minutes later, how to clean blood from wood and floor. 10 minutes after that, luminol to detect blood. All right. About an hour or so later.
6-year-old is Dexter in the making.
Yes, a little over an hour later, what happened when you put body parts in ammonia?
Agreed.
About 15 minutes later, is it better to throw away crime scene clothes or wash them? Age-old question, that is. Age-old question. Moving on. Trooper Proctor averred that there was probable cause to believe Brian committed the crimes of kidnapping and misleading a police investigation based upon the foregoing facts, including Brian's inconsistent statements, internet searches, and the fact that Anna had not been located, nor had there been any activity from any of her accounts.
All right, you want me to take over for a bit? You've been
you
doing
can do
yeoman's work.
the Volkswagen.
All right, Volkswagen warrant. So Trooper Proctor submitted the affidavit for the Volkswagen warrant. Footnote, once again, Trooper Proctor incorrectly listed February 9th, 2023 as the date he submitted the affidavit for the Volkswagen warrant. Oopsies, typo. I made a typo. The application sought installation of GPS tracking on the vehicle registered to Diana Walsh, Brian's mother, and in the possession of Brian. The Quincy District Court issued the warrant on January 8th of 2023. The warrant affidavit set forth the exact same facts as in the Walsh residence warrant affidavit. It further offered information about the use of GPS surveillance tracking systems, specifically MSP Lieutenant David Krause, the electronic surveillance equipment tech assigned to the special services section of the MSP, had informed Trooper Proctor that GPS surveillance systems are installed on a target vehicle without the target's knowledge, and they calculate the position utilizing satellites orbiting the Earth. Law enforcement can obtain the position of the target vehicle using mapping software through a cellular phone installed in the vehicle, and may obtain current as well as historical locations of the vehicle. Based upon the facts in the affidavit, Trooper Proctor averred that there was probable cause to believe that Brian had access to and the ability to operate 3 vehicles currently in the driveway of the Walsh residence, which included the Volkswagen registered to his mother, and that Brian may be a flight risk. Trooper Proctor further averred that there was probable cause to believe that Brian committed the crimes of kidnapping and misleading a police investigation, and the use of GPS device would enhance the investigation by quickly identifying locations, durations of stops, and frequencies of locations visited by Brian. 3, as to the MacBook A1534 warrant, the MacBook A2159 warrant, the iPad 6 mini warrant, the red iPhone warrant, the Mac A2179 warrant, the black iPhone warrant. Sounds like you had a couple of phones, babe. iPad A2603 warrant and iPad 6 warrant collectively.
So what they did was, and it's mentioned in this footnote, is they grouped all these together because they were all certain, sought at the same time. And this one other iPad, the iPad A1474, was 2 months later. So they discussed that warrant completely separately. I'm just going to summarize this beginning part that they say Trooper Garino said that he's got all this experience and he's specialized training in Cellbrite, X-Ways Forensic, Axiom, that he conferred with Sergeant Keefe, who has specialized training in computers and cell phones. He holds a certificate from the International Association of Computer Investigative Specialists as a forensic computer examiner and mobile device examiner. So the court did issue electronic warrants for those devices on January 10th, on 9th, and Trooper Garino also used the wrong date because you know what they love to do? Copy and paste from an earlier warrant. So one
just
mistake.
Copy and paste in. So Dana says, until someone like Brian Walsh goes free for what these police officers are doing, they will continue. They knew Karen was innocent, so they know if she went free, she wouldn't be a danger to anyone. So, I mean, you're preaching to the choir. You're on a defense attorney's YouTube channel. We're always trying to tell you guys, the reason that these suppression motions have to have teeth is for exactly that concept. If they don't get called out on their shit, and it's not just these shitty cops, it's any shitty cops all over the country, any shitty cops that are violating people's rights or planting evidence or any kind of malfeasance that they're getting up to. If we being a defense attorneys, don't call them on their bullshit, and they don't get body slammed in court, losing their evidence, thereby losing the case because they no longer have the evidence to prosecute it, then, they'll continue to do what they do. So your point's well taken. It's scary to think, that you could potentially let a guy who potentially did this to his wife walk because of police corruption, malfeasance, just overall ineptitude, whether they're violating the law intentionally or out of ignorance, whatever the case may be. It's a scary proposition. However, it has to be done in cases, no matter how grievous and heinous the crime is, right? Because we just can't allow for it. Because if it goes unchecked, that's when you get rogue cops thinking they can do whatever they want to do whenever they want to do it. So that's, I mean, we've been saying that for years, long before this Brian Walsh thing. We've been practicing it for years in courts of law, because that's how we protect us, the citizens, from the government, and the cops are
Right.
the government. So,
Right. And then
all right,
so to go over real quick what the warrants encompassed. So basically encompassed everything on these devices: documents, photos, electronic files, email accounts, web browser history, searches, everything, including GPS data from December 25th of 22 to January 8th of 2023 that is related to the disappearance of Anna and the misleading of the police investigation. Then they got user data, notes and journals in Word regarding Brian's activities from December 25th to January 8th, call logs for that same date period, and chats, text, and other messages and communications from December 25th, 2022 to January 8th. Uh, Health data from December 31st to January 8th, and then information showing ownership of the electronic devices. So the affidavits supporting the warrants included the information Garino gathered during his investigation and that he learned from the troopers and the detectives at the Cohasset police. And the affidavits
did you
contained,
wrestle the reading away from me somehow?
yeah, because I'm trying to summarize this, and it contained all the information
Wow.
that was in the residence for the because this one is more technical and less involved with their misconduct than the earlier one.
Well, yet
So
you say that, yet this was allowed in part. So clearly there is some misconduct here. And she found that there was no misconduct related to the consent
right,
search.
well, not misconduct, but overbroad, I think, is probably because that's what was argued with these. So we'll see. I'm just getting through the stuff that doesn't really. But you can continue then from on January 4th.
Why, thank you, madam. How sweet of you. How kind. How very kind. I just don't want you to get, winded, because you read like 8 pages there. So on January 4th of 2023 at approximately 6:35, David Schmidt, or Detective Schmidt, arrived at the Walsh residence for a follow-up investigation, at which time he conducted an audio recorded interview with Brian. Is this the one where there's one where we get to do a little tete-a-tete, little reading? So at the conclusion of the interview, Brian consented to a search of the house and the surrounding property. Brian led Schmidt around the residence and the property and identified items of potential interest in the missing person investigation before leaving the scene. This is where it's interesting. Schmidt observed the back of a 2019 Volvo XC90 bearing the MA registration, that with the third row raised. Lining the floor of the trunk area was an opaque off-white thin piece of plastic. The next day, Schmidt went back and re-interviewed Brian. At the conclusion of the interview, Brian consented to a search of the Volvo. The third row seat was now folded down and the mats were laid on the floor of the trunk. There was a light brown dirt on the floor mats. The carpet on the floor of the truck appeared freshly vacuumed. When Schmidt asked Brian where the plastic truck liner was from the night before,
Trunk liner.
Trunk liner was from the night before, he stated that he had put it in the trash cans. So on the morning of January 7th, 2023 at 5:18 a.m., Cohasset Police Detective Schmidt received an email from Dick Walker, 9984 at gmail.com, stating the following: "We have the so-named Anna Walsh here with us. We had a deal worth $127,000. She messed up. We have her here with us. And if she doesn't pay the money, then she'll never be back. And we know that the police and the FBI are involved. Good luck finding us."
Gonna make it 127, so everybody's
what a-
wondering why that number?
was that? Is this from like the John Benet Ramsey handbook of ransom notes? It's equally weird and shitty. So investigators considered this email sus because it contained no timeline to respond to the demand and no contact instructions. On January 7th, Trooper Keefe analyzed location information extracted from Brian's cell phone using the Cellebrite physical analyzer. Doing an interview earlier that day, Brian had told investigators that the only place he visited on January 2nd, 2023 was an ice cream shop in Norwell called Press. However, location data from Brian's phone, did this guy go to a fucking ice cream shop? Like after doing all this shit? What a fucking creep. Location data from Brian's phone showed that on January 2nd, 2023 at 4:12 p.m., Brian's cell phone was at the Home Depot in Rockland about until 4:56 p.m. On January 8th of 2023, MSP Trooper Moore traveled to the Rockland Home Depot to review security video from January 2nd of 2023. The footage showed that between 4:12 and 4:56, Brian was pushing a shopping cart containing cleaning products, including 3 mops and brushes, 2 large clear tarps, a drop cloth, 2 rolls of heavy-duty tape, a Tyvek suit with a hood, boot and coverall, and a mop bucket with a wringer. Wow. On January 8th, police executed the Walsh residence warrant. Located in the basin was an unopened 10 by 20 foot heavy-duty canopy tarp, which appeared on an itemized receipt that the Home Depot had provided Trooper Moore. Police also discovered a roll of plastic consistent with the plastic Detective Schmidt observed in the back of Brian's Volvo on January 4th of 2023. Uh-oh.
I thought he didn't buy it, though, until January 8th.
What do you mean?
I don't know. They said that
It's January 2nd. He went to the depot.
Oh, January 2nd.
Yeah, because
January 8th, they executed the warrant. Sorry.
Correct. Keep up, Ben.
Oy, I'm trying.
Oi.
Okay.
Police also discovered a roll of plastic consistent with the plastic that Schmidt observed in the back of Brian's Volvo on January 4th, 2023. Police seized numerous electronic devices from the home, including 3 MacBooks, 2 iPhones, and 3 iPads. During the 4 occasions police interviewed Brian between January 4 and January 8 of 2023, he gave statements regarding a trip to Whole Foods and CVS in Swampscott that the officers interpreted as willful attempts to mislead investigators. The statements wasted resources and delayed the search for Anna. Further, investigators identified multiple instances where Brian, who was on federal probation, monitoring that required him to request to leave his residence, traveled to locations that he did not disclose to his probation officer. Based upon the facts in the affidavit supporting the electronic devices warrants, Guarino averred that there was probable cause to believe that Brian committed the crimes of kidnapping, misleading a police investigation, and disinterring a body. Based on Guarino's training experience and information he learned by conferring with Sergeant Keefe, the affidavit also set forth the capabilities of electronic devices, and particularly Apple products. According to Guarino, electronic devices are capable of conducting internet searches. No,
wow.
You don't say. He is an expert.
Definitely.
Storing large amounts of data and connecting to external devices via universal serial bus cable and Bluetooth signals. Apple computers, cell phones, and tablets have the capability of sharing files between one another using Bluetooth signals. AirDrop! Apple devices which share the same Apple ID will share information such as internet searches across those devices signed in through Apple's iCloud services. The Apple iPhone can be paired with a smartwatch or fitness tracker that will record distance traveled, heart rate, and calories burned. An iPhone can also store financial information and be used to make purchases at select locations. So Guarino further averred that based on the officer's training and experience, they know that people who commit criminal offenses often communicate prior to and following a crime, and often
communicate. Hey, wait. They communicate prior to and following a crime. And often
when people commit crimes, they text their friends. That's what my training experience tells me.
It doesn't even say about the crime. It's just like,
I'm just talking to my friend. You want to go get a beer?
Communicate with their victims prior to and following a crime.
Oh, I tried to text Anna.
People also often transport portable devices from location to location, and the devices connect to various Wi-Fi connections with ease. A search of an electronic device may reveal log files and file remnants concerning communications, use of internet service accounts, as well as internet access to various websites. According to Guarino, it was reasonable to believe in this case that electronic devices were accessed to communicate with others before, during, and after the commission of the suspected crimes.
Wow.
Lastly, Guarino averred that the historical GPS data associated with electronic devices would contain evidence of the physical location of said devices. According to Guarino, the information and evidence associated with a particular device would contribute to identifying the locations from which the device departed, where it traveled, and the time it remained at various coordinates. The devices would also store subscriber information, as well as telephone numbers recently dialed, calls received, and information related to contacts. So Guarino believed obtaining access to the electronic devices would materially aid the investigation.
So I know we joke about the way this is worded, but by using the phone to communicate, it's creating the log and tracking the GPS. So it's just, odd the way they word these things, and they don't really wrap it back around. But
Right. Okay, so in pertaining to the iPad A1474 warrant, Guarino submitted the app for that, and the Quincy District Court issued it on March 9th. Police recovered the iPad from Anna's residence in D.C. That warrant sought documents, photos, audio, video, visuals, files, electronic communications, emails. Yes.
I was just going to say, requested all the same things, but this time, instead of the December date, they used November 17th, 2022 to January 7th of 2023.
Bigger time frame.
Right. And again, it was related to the disappearance. This time it was related to the disappearance and murder of Anna and Brian's misleading of the police investigation. It also included FaceTime logs from that
You just
same.
keep really slipping in there. You really keep slipping in. I was summarizing that very nicely, I might add.
Oh, you were?
You just slip right in. I mean, just slipped right in. All right, you go.
All right. So they also requested FaceTime calls and logs from that same time period. And again, information showing ownership and any communication between Anna and Brian, other family members or friends from that same November 17th date through January 7th. And communications and records relating to Anna and Brian's state of mind or motive, including financial records, life insurance policies, divorce, child custody disputes, or marital discord. Again, that warrant reiterated the same facts in the Walsh warrant that we already went through, and it contained the following additional information. Go for it, babe.
Oh, it gets worse. In addition to the internet searches occurring on December 27th, 2022 and January 1 of 2023, which we've already read to you and were quite damning, that were extracted from the iPad mini belonging to Anna and Brian's son. A search of that iPad mini revealed other internet searches conducted on January 2nd and 3rd. These included January 2 at 12:45 p.m. Hacksaw, the best tool for dismembering a body. January 2, 1:10 p.m. Can you be charged with murder without a body? January 2 at 1:14 p.m.
Guess he learned the answer to that question.
I guess he knows now. Can you identify a body with broken teeth? Oh my God. January 3rd, 1:02 p.m. What happens to hair on a dead body? January 3rd, what is the rate of decomposition of a body found in plastic bag compared to a body found on a surface in the woods? January 3rd at 1:20, can baking soda make a body smell good? What the fuck? Several of the internet searches conducted on January 1 occurred prior to the time Brian stated that he last received a kiss from his wife before she left the Walsh residence. The searches for how long before a body starts to smell and how long or how to stop a body from decomposing occurred less than 4 hours after the time when Anna was last seen alive at the Walsh residence by Jem. On January 7th, 2023, Keefe analyzed location information extracted from Brian's cell phone using Cellebrite software. It showed that on January 2nd, 2023, at 9:44 a.m., the device was in the area of Home Goods in Norwell. Surveillance footage from the Norwell Home Goods showed Brian pushing a shopping cart and purchasing 3 rugs, among other items. Later in the day, Trooper Moore observed video footage from the Rockland Home Depot showing Brian purchasing several items, including 2 splash-resistant goggles,
Oh
a
my God.
strip utility knife, 2 12-pound bags of baking soda,
Mm,
cat shit.
Jeez, my God. Oh my gosh.
Yeah,
Just
this dude needs to plead
put on
out.
his goggles and go into town. Oi.
He needs to plead out.
Oh,
Brian's cell phone location data showed that after leaving the Home Depot, he made a trip to Derby Street in Hingham, lasting from 5:15 to 5:32. Video footage shows Brian left the jacket, black face mask, and blue rubber gloves he was wearing while at the Home Depot in his car, walked to a trash can on Derby Street, and discarded small trash bags.
wait, he was
Location-
wearing a I'm still worried about COVID kind of thing. That kind of mask.
I guess. Doesn't
And he was wearing blue rubber gloves.
They're not calling it a balaclava, so I guess it's
Blue
just
rubber gloves?
I mean, that's not sus at all.
No.
I mean, not at all.
Gotta throw those things out.
Yeah, location data also showed that on January 3rd, 2023, Brian's cell phone was in the area of the Claremont apartment complex in Abington from 4:27 to 4:39, a solid 12 minutes. Investigators observed video from the area showing a man consistent with Brian's appearance exit Brian's Volvo and walk towards the dumpster carrying a garbage bag that appeared to be of significant weight. Subsequently, at approximately 4:48 to 4:52, Brian's device was in the area of the Point apartment complex in Abington, but there was no video of the dumpster area. Brian's device then went to the area of Chatham West apartment complex in Brockton from 5:10 to 5:16. Video from that area shows a man consistent with Brian's appearance exiting the Volvo and discarding items in a dumpster. Investigators worked to track the dumpsters at various locations, but the items had already been shredded or incinerated by the evening of January 8th of 2023. On that same day, while executing the Walsh residence warrant, MSP members assigned to the crime scene and members of the state crime lab conducted testing on various surfaces and floors within the home. Multiple locations in the basement and staircase leading down to the basement tested positive for blood. A knife that tested positive for blood was located next to multiple bottles of hydrogen peroxide inside a cabinet above the kitchen's refrigerator. Still on the 8th, Schmidt and DeChico and Guarino interviewed Brian at the Walsh residence. Attorney Minor was present for the interview. During the interview, Brian stated that on January 1, he went to the CVS in Danvers. Hey, we were just in Danvers.
So that's why
And
she's
we went to
saying
that
they went
CVS.
to the wrong CVS.
Hey,
That's why they're saying they went to the wrong CVS, because it was in Danvers, not Salem
Well,
or
Brian changed the story again.
oh.
I mean, they went to where he said he went, and now his story is that he went to the CVS in Danvers.
And then they caught him.
So investigators observed Brian on video at the Danvers CVS purchasing and shoplifting. Hey, see? He is a fucking shoplifter, cleaning products. The officers confronted Brian with the iPad searches about dismembering and disposing of a body conducted prior to the time he stated he last saw Anna at the home.
So now we gotta apologize to, what was her screen name?
Who?
Despite my face, you're still talking.
I'm not, what? No.
She was
said
right.
that they went to the wrong ones.
Oh, but you're
They
saying
went
that's
to
what
the
he
ones
said the
that
first
he-
time. Okay,
Right.
all right.
Oh, he's
Disregard it.
changed his story.
He's changed the story. I got it.
Correct.
Okay.
This is the 4th interview of this guy, or 5th.
Oh, he's like, oh yeah, Danvers.
oh, yeah, that's it.
The officers confronted Brian with the iPad searches about dismembering and disposing of a body conducted prior to the time that he stated that he last saw Anna at the home. Brian offered no explanation other than the iPad.
That's my kid's iPad. I don't know. Ask him. Hey, Timmy.
You know what? He's put it on his kid. DeChico asked if Brian's 6-year-old son was of average intelligence, and Brian stated, "I'd like to think so."
Yeah, the whole point was, is he above average? That he's, you know,
What does formaldehyde do?
right.
Attorney Minor offered the possibility that Anna had performed some of the
Wait,
searches.
wait, sorry. We skipped a line. When told the searches had no misspelled words, he offered no explanation.
Or maybe he used speech to text.
That's suspicious.
That's suspicious.
When he, Attorney Minor offered the possibility that Anna had performed some of the searches on the iPad herself. Solid lawyering there, Minor.
Yep.
Hey, maybe it was Anna. Maybe she was going to kill Brian. Maybe.
But when asked to explain how the searches continued after Anna was said to have left the home, Brian, and it sounds like his lawyer, offered no explanation, and Attorney Meyer then terminated the interview. Well,
This
she's like,
is
"Oops,
over.
done,
Out.
done."
Out.
Well, I
You get out.
suppose.
I'm finished with this guy.
Finish with this guy.
The same day, police arrested Brian and charged him for intentionally misleading a police investigation. They just wanted to get this dude off the street. They wanted to make sure he didn't flee. So that charge doesn't mean shit. It just got him into custody. It's like the Gacy weed bust. The same thing went on.
All right.
So on January 9, 2023, investigators executed a search warrant on Brian's Volvo. Swabs taken from the weather mat in the trunk of the vehicle and the electronic adjustment buttons along the driver's seat indicated the presence of blood. The same day, investigators continued to review Brian's cell phone data. They observed that on the 5th of January, Brian traveled to where his mother resides. But unlike a previous visit on December 27th, 22, this time he remained in the southwest corner of the complex near the dumpster for 5 minutes before leaving. MSP Trooper Katkowski secured the dumpster. A search revealed 10 trash bags. The contents were documented, bagged as evidence, and secured. Among the items were towels, rags, slippers, plastic sheeting, tape, a Tyvek suit, gloves, cleaning agents, carpet, rugs, hunter boots, a Prada purse, foreign currency, Anna's COVID vaccination card,
Wow.
saw, a hatchet, heavy-duty cutting shears, and a hammer.
Oh my
Oopsies!
gosh.
Oopsies. The boots and purse were consistent with what Brian had described Anna as possessing when he last saw her on January 1st of 2023.
Oh my Lord.
Many items contained red, brown stains consistent with blood. Preliminary testing on a portion of the rug, which was heavily stained and red, brown in color, showed a substance consistent with baking soda, which we know that he bought 12 pounds of. Scrapings from the rug also revealed a metal bar with the name Gucci imprinted on it and consistent with the necklace Anna wore in photos. The state crime lab performed testing on selected items secured from the dumpster. The slippers, the Tyvek suit, and the tissue showed the presence of DNA. Further testing of the DNA from the slippers and the sleeve cuffs of the Tyvek suit matched Anna with Brian as a contributor.
Oh,
DNA
Lord.
testing the exterior left pant leg and the interior right sleeve of the Tyvek suit and from the tissue included Anna as a contributor.
I just have to say, after all this, I'm done with this case. Like there's nothing to follow. There's nothing I need to know.
It needs to fucking plead out.
I needs to just plead out.
I just hate him. I hate him. I hate him.
The information collected during the, as you can see, if you're a judge reading through a motion to suppress, reading the evidence that they've found, and you are charged with the task of deciding whether or not to grant a motion to suppress, you can see what Allison and I were talking about in our last live regarding this case. The judge is going to bend over backwards to find an exception for which she can hang her hat on in order to
So that all
deny
this evidence
motion to
doesn't get
suppress.
tossed.
Right. She doesn't want this guy walking. This guy
No.
clearly did it. Clearly. So the information collected during the investigation caused the police to suspect that Brian had in fact killed Anna, dismembered her body in the basement of the Walsh residence, and disposed of her body and other items in various dumpsters. This information included the internet searches, untruthful statements, presence of blood in the basement, Brian's purchase of cleaning supplies and cutting instruments, the presence of blood in the rear of Brian's Volvo, video evidence of his multiple trips to 6 dumpsters in 5 days, and the items recovered from the dumpster in Swampscott.
Oh my God. All
Investigators
of this could have been
reviewed-
tossed. All of this. They
Had she
fucking
granted the motion that we didn't start with the memorandum of opinion on, or her ruling, all this is gone. All of it. Had she granted that first one. Because it all comes from that. It's that fruit of the poisonous tree. So investigators interviewed many of Anna's close friends, colleagues, sister, and mother. No one has heard from her since the early morning hours of January 1, 2023. There's no indication that she would have voluntarily disappeared, and she had made future plans for herself professionally and personally and for her children. So the Verizon warrant,
and we can just summarize this, that they
okay,
sought,
summarize it. You go, girl.
yeah, they sought the Verizon warrant. They went through the, you've got Trooper Keefe. He's real well trained. They sought call records, location information, subscriber information from January 1st, 2023 to January 8th. And from December 30th, 2022 through January 8th. The affidavit included all the stuff that they had, before. Used both Brian's cell phones were used since Anna's disappearance. He made an outgoing call to travel to the Rockland Home Depot, and purchased items to dispose of Anna's body, is what they believe. Brian had the phone with him from January 1st. So they go through all of that. And that Brian had the phone on him on January 1st, 2023, when police observed him on surveillance footage at Lowe's, purchasing over $450 worth of tools, including a hacksaw, as well as cleaning supplies, another trip Brian had not disclosed to investigators. The warrants reiterated the information from the previous affidavits, report of the missing persons, the consented to search of the iPhone and the iPad mini, the search warrant of the Volvo, the location data, and the items recovered from the dumpster in Samsquat or Swampscott.
You just said that how I say, actually how Bub says Sam Squanch.
Yeah. And then they had the additional information that on that Jem on January 6th, that he stated that he sent Brian and Anna a message on the same thread on January 1st at 11:40 a.m. Anna never responded, and Brian responded on January 2nd, telling Jem that his child had just found his phone. On January 4th, Brian called Jem and sounded distraught and a little off. Brian told Jem that he had not heard from Anna in 3 days, and she had left early morning for a work emergency. Jem asked Brian if he and Anna had an argument after he left, and Brian responded something to the effect of, did it look like we were arguing? Well, he asked after you left. Jem provided to police the names of people who he knew and who knew Anna well, including her friend Alyssa Kirby and Will Fasto. On January 7, MSP Sergeant Yuri Bukhenik and Detective Lopes went to Washington, D.C., and spoke to Fasto and his attorney. Fasto resides in D.C. and was the most frequent contact with Anna. That's the boyfriend, that they had spent time together Thanksgiving and Christmas Eve. They were open about their relationship in D.C. and had plans to celebrate New Year's Eve on January 4th when she returned from Massachusetts. Investigators also spoke to Kirby. She told them that Anna and Brian's marriage was strained, that Anna was planning on having the kids live with her in D.C. Anna had reportedly given some sort of ultimatum to Brian about the resolution of his federal criminal case and wanted the kids to be with her. When investigators viewed Anna's residence in D.C., they observed it to be ready for the kids to move in with the other items present. The affidavit supporting the warrant contained the following additional information. The other Verizon warrant. Investigators interviewed the nanny, Robin. Robin told police that Brian asked her to watch the children on January 1st from 2 p.m. till 7 p.m.
Wow.
Brian had previously told Robin that he and Anna were going to have brunch that day, but when she arrived, he said Anna had to return to Washington, D.C. for a work emergency and he had errands to do. So, all right.
That
That
answers
was
that
my
question.
that answers that question. Right.
Yep.
She observed that Brian, who was generally calm and collected, appeared preoccupied that day. He left around 2, returned at 4 p.m. and 5 p.m. to drop off pizza, and then went out again. Robin observed one of the children had a new iPad. She said that Brian's mother, Diana, was always buying new iPhones and iPads for the children. Brian returned between 8 and 8:30. After further investigation, investigators discovered the iPhone with the phone number ending in 8028 was present at Home Goods in Norwell on January 2nd when Brian was seen on surveillance video purchasing 3 rugs and other items at Press Juice Bar. Although Brian stated he had lost or misplaced his iPhone 13 on December 31st and did not find it until January 2nd, he had the care, custody, and control of iPhone ending in 8028. The affidavit supporting both Verizon warrants explained that based on Trooper Keefe's training and experience, he knows people frequently employ cell phones as a primary means of communication, and suspects involved in criminal behavior often bring it with them. So this is all just everything going back over why they need all this, and they believe it's going to show evidence for both phones. Trooper also explained in his experience, cell phones can provide estimated distance between the call and a cell site, GPS information, and confirm Brian's movements during the planning, execution, and disposal of evidence, assist in establishing a timeline. So now we get into the law. Go for it, babe.
The law. So discussion. Under the 14th Amendment and Article 14, a search warrant may issue only upon the showing of probable cause. That comes from Commonwealth v. Martinez. For probable cause to arise, the facts contained in an affidavit plus the reasonable inferences that may be drawn from them must allow the magistrate to determine that, quote, the items sought are related to criminal activity under investigation and that they reasonably may be expected to be located in a place to be searched at the time the search warrant issues. So in dealing with probable cause, as the very name implies, deals with probabilities. These are not technical. They're factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. And that comes from Commonwealth v. Cop. Oh, by the way, Mandy says that it's not Anna, it's Anna.
Oh, sorry, Anna.
I was saying Anna too. In reviewing a finding of probable cause, search warrant affidavits are to be interpreted in a realistic and common sense manner and should be read as a whole, not parsed, severed, and subjected to hypercritical analysis. And that's Commonwealth v. Anthony. An inference drawn from the affidavit, quote, if not forbidden by some rule of law, need only be reasonable and possible. It need not be necessary or inescapable, citing Kaup. Moreover, a, quote, reviewing court gives considerable deference to the magistrate's determination of probable cause, and even, quote, the resolution of doubtful or marginal cases should be largely determined by the preference to be accorded to warrants, unquote.
So let me jump ahead. So with the Walsh warrant, the defendant argued that it was overly broad. The court found that it was not overly broad. He obviously asked that it get excised the information that they got from the searches, and the judge said she denied it. So that wasn't the case. And ultimately, she found that the affidavits here showed that Brian had not contacted police. So this is what she believes is probable cause. The affidavit here shows that Brian had not contacted police, even though his wife had been missing for several days, and that his account of what occurred on January 1st, 2023 did not match the other information investigators had obtained. There was no evidence that Anna had left the Walsh residence in an Uber or a Lyft to fly to Washington, D.C., as Brian claimed, or that she had ever planned to do so. The surveillance footage at the store and store records contradicted Brian's statements that he went to Whole Foods and CVS in Swampscott that day, citing a Massachusetts case that the defendant's false statements to police and concealment of information contributed to a probable cause analysis of whether he was involved in a crime. Additionally, police discovered several internet searches made following Anna's appearance on Brian's son's iPad mini regarding ways to dispose of a body and clean up a crime scene. Taken together, this information was sufficient to establish probable cause to believe the defendant was involved in Anna's disappearance and was misleading the police and therefore had committed the crimes of kidnapping and misleading police. The affidavit also establishes a nexus between the crimes and the items sought. That was the other argument, that Brian made, that there was no nexus, which is just a word to mean connection between the items they were looking for and the crimes, including physiological evidence, items belonging to Anna, such as her clothing, jewelry, passport, wallet, and cell phone, electronic devices, and instruments of the crime as described on the warrant. It is reasonable to infer from the affidavit that Brian, the only adult in the home at the time the internet searches concerning the dismembering and disposing of and cleaning up after a dead body occurred, performed those searches. Thus, there was probable cause to believe that physiological evidence would be found in the Walsh residence, as well as the tools and cleaning supplies necessary to perform the actions identified in the internet searches. Footnote 13. In his memorandum, the defendant separately argues there was no probable cause for the items listed under Section E in the Addendum A to the warrant. Instruments of the crime listed in the iPad searches and the affidavit, including blunt force objects such as a hammer, knife, hacksaw, trash bags, etc., because these are all common tools or household items, and they're not generally related to criminal activity. Okay, Brian, nice. This argument appears to only apply if the court suppressed the internet searches due to a lack of consent, which, as noted herein, the court has not. Considering the content of the internet searches, police had probable cause to seize the items.
100%.
Yeah.
Yeah.
Returning to the body. The affidavit also explained that Brian was using electronic devices to make internet searches directly related to Anna's disappearance and to communicate about her disappearance in the time before police were aware she was missing. Therefore, there was probable cause to believe there'd be evidence of the crime on the devices. They again cite a Massachusetts state for the case for the proposition that a warrant authorizing search of defendant's apartment for telephone and computers, which could help detect identity of the victim, was supported by probable cause. Further, where there is no evidence that Anna had left the home and her phone pinged in the area of the home after she went missing, there was probable cause to believe the clothing she was allegedly wearing when she was last seen and her passport, wallet, and cell phone was, as well as the other items sought in the warrant, would be found in the Walsh residence. Accordingly, defendant's first contention fails. With regard to defendant's second argument, the warrant authorization to seize all electronic devices in the residence was not impermissibly broad. The fact that the internet searches about dismembering and disposing the body appeared on the defendant's son's iPod mini is significant. It was reasonable for police to infer that Brian made those searches either on his son's devices or on another Apple device synced to that iPad. In either case, officers could further infer he used various electronic devices to which he had access in an effort to cover up his crime. They cite another Massachusetts case from 2017, quoting, where evidence of child pornography could have existed on any or all electronic devices at the location associated with the target IP address, the seizure of over a dozen electronic devices found in the apartment did not exceed the warrant's scope. Also, the affidavit set forth that Brian was using his phone as well as some other electronic devices to communicate about Anna's whereabouts. He told investigators that while his phone was missing, he emailed his mother and business partner to tell them Anna was missing. Okay, so there you go. He's saying Anna's missing before he knows Anna's missing because as far as he knew, he was just missing her calls because he didn't find his phone. So, returning the body. He further explained that upon locating his phone, he texted Anna multiple times and reached out to her friends and family to inquire if they had heard from her, and that he contacted Anna's work about not being able to get in touch with her. Thus, Brian was using more than one electronic device to communicate about Anna during the time she was missing. So based on all of that, he loses.
You lose.
Right. Accordingly, there's no basis to suppress. The Volkswagen warrant. So this is where things get tricky. The defendant challenges the warrant authorizing police to install a GPS tracking device on the 2013 Volkswagen Beetle registered to Brian's mother and parked in the driveway of the Walsh residence. The court agrees there was no probable cause for this warrant. the surreptitious installation of a GPS device on a motor vehicle is a search or a seizure, and thus requires a search warrant. Warrants for GPS monitoring of a vehicle may be issued under the court's common law authority in circumstances where there is probable cause to believe that a particularly described offense has been, is being, or is about to be committed, and that GPS monitoring of the vehicle will produce evidence of such offense or will aid in the apprehension of a person who the applicant has probable cause to believe has committed, is committing, or is about to commit such offense. Again, citing 2 Massachusetts cases. The warrant at issue does not meet the standard. The warrant authorized the GPS tracking of the Volkswagen for 15 days from the date of its issuance, January 8th, 2023. Footnote 14. The warrant return indicated that Trooper Proctor installed the device pursuant to the warrant at 3:30 a.m. on January 8th. Police arrested the defendant later that day. However, the affidavit supporting the warrant did not offer any information as to how monitoring the Volkswagen would produce evidence of Brian's alleged kidnapping of Anna or misleading the police investigation or aid in his apprehension for such crimes. Other than stating that the Volkswagen was currently parked in the driveway of the Walsh residence and that Brian had access to and the ability to operate it, there was no information in the affidavit connecting the vehicle to Brian's crime. Footnote 15. The information about this vehicle stands in sharp contrast to that of the Volvo. Brian told police he used the Volvo to run errands on January 1st, the account of which police later discovered was not entirely true. Turning back to the court's assertion that there was no information in the warrant that connected the vehicle to Brian's crimes, they cite a Massachusetts case for the proposition that information in an affidavit describing defendant charged with arson using a pickup truck to drive away from the scene of the fire was sufficient for GPS tracking on the defendant's truck. While the affiant averred that having access to 3 vehicles suggested that Brian may be a flight risk, there is no facts in the affidavit from which it can be inferred that Brian was considered a flight risk, nor is it clear how the court having access to more than one vehicle increases a suspect's flight risk. Because the affidavit supporting the Volkswagen warrant was not supported by probable cause, the court will suppress any evidence obtained from that warrant, which I can't imagine what that is. But
see that, I mean, that was there was nothing. So that was an easy one to say, okay, I'll grant this one because they didn't find shit in the Volkswagen.
So then they did that one other iPad that they're calling A1474. And they seized that much later in the investigation. It was a device they obtained from Anna's residence in Washington, D.C. And the defendant argues that 1, all the affidavits supporting these warrants lack specific evidence linking the electronic devices to criminal conduct. 2, that the affidavits impermissibly rely only on general presence of the cell phone in daily life and officer experience. And 3, they are overly broad in terms of time frame and items sought. None of these arguments have any merit. So they go on to talk about establishing probable cause for computer-like devices, and that they have to obtain information that establishes the existence of some, quote, particularized evidence related to the crime that they believe likely to be found on the device. Doesn't need to be specific. It must be specific and not speculative. Evidence linking the device in question to criminal conduct. The warrant affidavits at issue meet this standard. So for the same reason as they denied it in section 1, the affidavits explained how she went missing, that he utilized electronic devices for the searches, and that he used more than one electronic device to send texts and emails. So basically for all the same reasons before, the court found that that these electronic devices were also in play. The court says, thus, the affidavits established probable cause to believe that Brian's electronic devices would contain evidence of Anna's disappearance and Brian's efforts to mislead the police investigation. Footnote 16, at hearing on the motion, the defendant argued that the police should have sought a warrant for the iCloud information rather than for each individual device. While it may have been possible for police to retrieve some of the information sought through other means, they were not constitutionally required to do so. The defendant's second argument, that the affidavits did not rely on only the court found that the affidavits did not rely only on general evidence about cell phones. Rather, as noted above, they provided detailed information regarding how police believed Brian used electronic devices in the commission of the crimes and why they believed the information sought would be on his phone. With regard to his last contention that the items seized, that the warrants were overly broad, the court said, to be sure, the warrants authorized the search of a significant amount of information from the devices. This includes all communications, email, text, etc., browser, search history, photos, data, all the things and such. However, the warrants were directed at information that police expected to find on the device based on what they had already uncovered during the investigation. The court went on to say, moreover, the warrants were limited in scope to items that related to the disappearance of Anna Walsh and the misleading of the police investigation, or related to Brian Walsh's activities regarding this investigation. As such, the warrants were clear about what they were seeking on the devices and specifically identified the type of evidence sought, so they were not overly broad. The court denied his other arguments basically for the same reasons. And they note that the affidavits were, they were limited in scope to dates and things of that nature.
Yeah, I mean, the one thing that we know is they didn't find any evidence of substance in the Volkswagen. They didn't find anything that is going to be damaging to the case in terms of what they found on Anna's iPad from the DC residence. So it's no harm, no foul.
Right. And then the court just also says there was obviously probable cause for all the reasons they said before that. He also challenged the Verizon warrants, and the court found that there was probable cause for those because the judge says there's no question here that the affidavits supporting the Verizon warrants provided probable cause to believe the defendant committed the crimes alleged. The affidavits contained additional information regarding Brian's purchase of tools, such as a hacksaw, police observations of Brian discarding items in various dumpsters, items police recovered from the Swampscott dumpster, Brian and Anna's strained relationship, Brian's attempt to mislead the investigation into her appearance. The affidavit further stated that Brian used both cell phones during the relevant time frame when Anna went missing and the police commenced their investigation. Where cell phones have become an indispensable part of daily life and exist as almost permanent attachments to the user's bodies, it may generally be inferred that the location data from a particular phone will yield suspect's location at any given time. Therefore, an affidavit establishing that the suspect committed the crime and that the suspect was known to own or use a particular cell phone provides the requisite basis to believe that location data will provide evidence of a suspect's participation or lack thereof in the suspected criminal activity. And insofar as the warrant sought CSLI, which is real-time location information. What is it? I know the LI is location information. But that's what it is. From January 1st to January 8th, the time frame was not impermissible expansive. The information, the affidavits outlined his actions from the January 1st to the 8th during that time frame, everything he did, how he bought all the things, and he went to all the things and such he did during that time frame. However,
shit.
With regard to the additional 2 days, December 30th and 31st, there was no probable cause to believe the location information data from those dates would contain evidence of the offenses. The affidavit explained that Ed told the police he last saw Anna around 1 a.m. on January 1st. There is nothing in the affidavit suggesting that police had reason to believe that a crime occurred before that point. Thus, there was no substantial basis to believe that the device would contain relevant evidence of a crime. That is, that the defendant's location at or around the time the crime was committed. because there was only probable cause to support the Verizon warrants from January 1st to the 8th, the court will sever the warrant and suppress the location data obtained from December 30th to December 31st. And that's why you've got some allowed and some denied.
Yeah, no harm, no foul on the on those two that she allowed, because I mean they just didn't find anything. I mean, I'm sure Anna's iPad probably had some shit that was like, oh, I'm searching for lawyers to divorce this guy, shit like that. But in terms of knowing that her life was in danger, I mean, maybe
Well, they were specifically talking about his location information during those earlier dates, that there was nothing to say he committed the crime earlier, so they didn't need to know his location.
For sure.
All right, so getting to the ruling on the motion that deals with whether or not there was consent and who is more credible. You ready to do that now?
Yeah. August. I know. I'm a big Trail Park Boys fan. I said it was Bubbles. That's what he calls a Sasquatch, Sam Squatch. That's what I call it because of that. I always call it a Sam Squatch. All right. Let me pull it up if I can find it. Let's see. Okay, I'm gonna open it again though, because my shit's doing something weird. Okay, it's 78, I think. All right, let me move it over real quick. Boop. Blow it up. So you'll see. Have you looked at this one yet?
Nope.
Okay. I think we can kind of like obviously factually, a lot of it's substantially similar. However, like kind of the things we want to look at in this are in particular the consent.
Oh, and the credibility findings.
I mean,
so read the intro, which summarizes everybody's argument.
All right, let me.
And then we'll go to her findings. You want me to do it?
No, I'll do it. I was just switching it over to. When you say the intro, you mean just the beginning? Are you talking about? Yeah, because they don't call it an intro. So Walsh has been charged with one count of red rum, one count of misleading police, and one count of unlawful conveyance of a human body. Brian moves this court to suppress evidence obtained in the course of an examination of data extracted from his cell phone and iPad 6 mini on January 7, 2023. Now, as we stated earlier, and we did a live on this motion, this was the scary one. This is the one that had this been granted, had this been allowed, all of the shit that we just talked about and all the other warrants goes away.
Or could.
Yeah. Most likely, if this was granted, it goes away.
Right.
I don't see how she's not.
Right, because you needed those searches.
You had to have those searches. So the defendant argues that he consented to the examination of only limited data extracted from those two electronic devices. Namely, his consent was limited to non-privileged communications during the time frame of December 25 through January 6 of 2023. Commonwealth counters that Brian consented to a full data extraction and examination of the two devices for the time frame of December 25, 2022 through January 6 of 2023, limited only to the exclusion of attorney-client communications. Court held a hearing on May 19th and 20th and June 18th and received testimony from 7 witnesses, a bunch of cops. Bukhenik was there, Fanning was there, Keefe was there, Guarino was there, and the attorney was there, Minor, Brian.
Which was, I think, part that was sealed because we didn't.
So these are all the pieces of evidence that were entered into evidence, the exhibits. Got 27 of them, various things, emails.
And then it starts off pretty interesting with her findings of fact.
Yeah, the findings of fact. So the court makes the following findings, which are based on the credible evidence produced at the hearing and the reasonable inferences the court has drawn from that evidence. The court finds that Officer Lawrence, Sergeant Schmidt, Sergeant Bukhenik, Lieutenant Fanning, Trooper Keefe, and Trooper Guarino were credible with respect to all material aspects of their fact testimony as reflected in the findings and rulings the court makes in this memorandum. As to Attorney Minor's testimony, remember that's Brian's lawyer, the court credits much of her testimony, but importantly does not credit her recollection of the agreed to restrictions on the examination of the data extracted from the electronic devices Brian consensually turned over to law enforcement on January 6th, 2023. More specifically, the court does not credit Attorney Minor's present recollection that law enforcement examination of the extracted data was limited to communications between Brian and other persons for the period of December 25 through the 6th of January. That recollection, more than 2 years after the interactions in question, is contradicted by and inconsistent with other evidence that the court finds more reliable and believable. Officer Lawrence has been a cop with CPD, Canton Police Department, for 6 years. Is it Canton or Cohasset?
Cohasset.
Sergeant Smith has been a member of CPD for 13 years and was a detective at the time he interviewed Brian on the 4th of January. In early January 23, he was promoted to the rank of sergeant. Sergeant Smith is a member of the Metrolec SWAT team, a consortium of police departments that shares resources and personnel to form specialized teams and include a search and rescue team. He has worked on dozens of cases, including fatalities and just over a dozen missing person cases. Of those missing person cases, several involved a death as a result of medical issues, suicide, and exposure to elements. Bukhenik has been a member of MSP for more than 13 years, has been assigned to the Norfolk County District Attorney's Office for the past 10, and was promoted to the rank of sergeant in December of 2021. Of note, Bukhenik memorialized a conversation he had with Minor on January 6th regarding the extraction and examination of data from the defendant's phone and the minor children's cell phone and tablet. Fanning has served with MSP for 20 years, and he achieved the rank of lieutenant in December of 2021.
Very credible.
Super credible guys. He has been assigned to the Norfolk County District Attorney's Office for the last 13 years.
Very reputable office.
Super reputable. I mean, is she oblivious to Karen Reed, or is she just choosing to ignore it?
I mean, she's got to for the purpose.
I mean, there's been recent filings. I think that
I don't know that we don't know whether we didn't hear them challenge anybody's credibility with that stuff, but I don't know if it was stuff that
well, there's been very recent filings just very recently where they're trying to get all the dirt on these cops. I'm assuming for a motion to reconsider in order to say, hey, judge, you know, all these people that you said were super reputable, well, they all suck. And here's the proof of it. Whether or not that will be, I mean, that could factor in, frankly.
It definitely could.
If she's oblivious. I mean,
she's not oblivious. It matters what was
oblivious.
presented to her. What she knows is of no consequence. It's what was presented in her courtroom.
Right, but she's finding them to be credible.
Right, but based on what was presented in her courtroom, not what she knows of her own.
Well, no, what I'm saying is if she doesn't know these officers to be not credible from other cases that are out in the public, I mean, right. She's judging their credibility right now is what I'm saying. So if she's given information that says, hey, we understand that what you heard in court and based on their training and experience and their promotions and all this shit, which I'm assuming were from Karen Reed, 2021, you say, all right, well, these guys all suck. So like, just look in the context of, I mean, are you thinking that if they
all I was saying is that even if she knew it, that didn't matter unless they presented it to her.
How can you say that? Like, I mean, like if you
what
know
she knows doesn't matter. They had to raise it in her courtroom and say, Your Honor, I'd like you to take judicial notice of what occurred in Karen Reed matter.
Yeah, but she's sitting here talking about their training and experiences, why she finds them more credible than his lawyer.
Correct. So whether she knows something of her own accord or not, if it was not raised and presented, she cannot say, I know these motherfuckers to be liars because they lied in Karen Reed or they did something shady in the Reed case. Like they need to the defense needs to put that in front of her before she can
Well,
rely
yeah,
on
that's
it.
what I'm saying. That's why I think they filed for these federal documents. They want the federal shit so that they can get all the dirt on these guys.
I think there was enough dirt in their testimony, but
I mean,
was
she
it
didn't.
who introduced the inverted video?
Bukhenik.
Right.
Yeah.
I mean, he
But
lied in a court of law,
obviously she didn't know shit about that.
or it wasn't presented to her. She might have known it.
She might have. She could, but I have to assume that she didn't. Like,
Okay.
like a judge is going to sit here and talk about how credible these guys are. Kind of has a little bit of egg on her face, even though I think I would probably be echoing the sentiment of most people. I'm glad this wasn't granted. You know, I mean, she clearly found enough in terms of their credibility to believe what they were saying over what the lawyer was saying. You know, who's an officer of the court?
Right, but her point was Bukhenik. Was it Bukhenik who took notes, or somebody took notes at the
It was
time?
Bukhenik, yeah.
Right,
He
they
took
spoke,
notes.
and she didn't. It sounds like, but let's keep going.
Yeah, so Guarino has been with MSP for 10 years. Since November of 2019, he's been assigned to the Norfolk County District Attorney's Office, where he's responsible for forensic investigations and SA investigations. Guarino attended specialized training in numerous digital forensic tools, including Cellebrite, Magnum Axiom, and Gray Key. Minor has been a criminal defense attorney practicing in both state and federal courts, mainly in the Northeast, for 40 years. Attorney Minor has represented Brian for the past 8 to 10 years. Minor has experienced negotiating agreements with law enforcement regarding the examination of electronic devices. So then she kind of goes through it. On the 4th, Lawrence was dispatched to the house, and he has a conversation with this guy, Hugh Dunleavy of Tishman Spire in Washington, who works with Anna, and Dunleavy reports that one of his employees has not been seen since the 29th of December, and that her car was last entered at Tishman Spire at approximately 5 a.m. on Friday, December 30th of 2022. Dunleavy reported that the parking area where Anna's car was last logged provided easy access to Reagan National Airport. Mr. Dunleavy reported that Anna lived in Cohasset, Massachusetts, and commuted back and forth to Washington, D.C. for work. When he arrived at the Walsh residence, he exited his cruiser, and Brian met him at the doorway, calmly reporting that his wife was missing and he wanted to file a report with CPD. Brian told the officer he'd last seen her on January 1st, so he basically tells the same shit. She ordered an Uber. He tried to contact her. She owned the townhouse in D.C. He also said that Anna drove the 22 Grey Ghost Volkswagen Taos in Washington, D.C. Described her as 5'2", 115 pounds with brown hair and brown eyes. The initial interaction between Officer Lawrence and Brian lasted for 20 to 30 minutes. So Lawrence then returned to CPT and filled out a missing persons report using the information provided by Brian. Thereafter, CPD conducted a follow-up investigation. Law enforcement contacted JetBlue and learned that there was no record of Anna flying the morning of January 1. Further, Uber indicated there was no record of a pickup or a drop-off at the Walsh residence. And they also contacted Washington, D.C. Metro Police and asked them to visit the Walsh's townhouse. Brian consented to the police entering the townhouse. Anna was not at the residence, and there was no sign of a forced entry. At approximately 6:30 on the 4th, Lawrence returned to the Walsh residence, accompanied by now Detective Sergeant Harrison Schmidt, to speak further to Brian. Schmidt had prearranged this interview to allow Brian sufficient time to feed his children. When the two cops arrived at the home, Brian was alone with his 3 children, 2, 4, and 6 years old. Family had a large German Shepherd who was inside the crate, and they interviewed Brian at the dining room table for a little under an hour. The 3 children were freely roaming around near where the interview took place. The interview was audio recorded, and a transcript of the interview was prepared.
The footnote just indicates that the court had listened to it and agrees with that both sides said that it fairly and accurately reflects the interview, and she wasn't going to detail the entire contents of the interview, but would refer to some of it as needed.
Yeah. So Brian then showed Schmidt his cell phone, in particular, a screenshot from his phone. He repeatedly encouraged Schmidt to look at his phone. Look at my phone. Please look at it. Please look at it. Please look at anything. And if you want anything further, there's probably a year's worth of text there. If anything of that is supportive, please, I'm open. So that's a quote from Brian from this interview. Brian explained to the officers that Anna sometimes used his phone to take photos and would send them to himself or to herself if she liked them. In addition, Brian told the officers that Anna's iMessenger came up on his phone and that he had some access to her Instagram account. While discussing his federal case, Brian told the officers, quote, "I don't want to hide anything from you because if that could lead to finding my wife sooner, that's the most important thing." End quote. Schmidt reviewed Brian's phone for approximately 3 to 5 minutes, looking at photos, text messages, and JetBlue flight information. After the interview ended, Brian gave permission to Lowrance and Schmidt to walk around the residence and look for any potential clues to help them find Anna. Inside, the officers went to the basement of the home. The basement was fairly clean, with a refrigerator and a couple of boxes of miscellaneous items and trash bags. Officers did not look in the attic of the house. Outside, officers observed a Volvo XC90 SUV in the driveway. Brian gave the officers permission to inspect the inside of the vehicle, and officers observed a folded up plastic sheet in the back of the SUV behind the vehicle seats. Officers also checked an in-ground pool in the backyard, which they found uncovered with a high water level. So on the 5th, Schmidt continued his efforts to find Anna. He created and disseminated a missing person bulletin, coordinated with Anna's family and friends, checked for any intentional or international travel, and flagged Anna's passports to alert him if she attempted international travel, coordinated with taxi companies and ride shares and Anna's employer. In addition, he arranged for a CPD canine search of the Walsh residence. Nothing was recovered in the canine search. So he must, at this point, obviously, on the 5th, he had not started doing all of the dirty work yet.
Well, where the hell is he cleaning up?
What I'm saying is the things that they found in the basement on the search in the 8th, that must have happened between the 5th and the 8th, because that they found all that shit in the basement. You know what I'm saying?
Wait, they found all that shit. Oh, some shit in the basement, and then all that shit in the dumpster at his parents, his mom's dumpster.
But that's all after the 8th. What I'm saying is I don't think he did the dirty deeds of this, the dismembering part, until after this interview took place. Like where else is he doing it?
Yeah, I don't know.
Because if there's none of the evidence, because they went down to the basement,
right?
He probably did like maybe she was up in the attic. I mean, they noted in there that they didn't go up to the attic for whatever reason. So also on the 5th, Schmidt's supervisor requested the assistance of MSP, Chico, and Bukhenik, arrived at the Cohasset Command Center in the late afternoon on the 5th.
Oh, babe, sorry. They said that on January 5th, Brian traveled to his mother's residence and stayed by the dumpster. That was on the 5th. And then they found...
was that the 5th?
It says that on the 5th, investigators continued to review Brian's cell phone data. They observed that on January 5th, Brian traveled to where his mother resides, but unlike previous visits, this time he remained in the southwest corner of the complex near the dumpster.
Is that the dumpster where they found all the shit?
Oh, yeah.
The 10 bags?
The towels, the rags, the slippers. No. They found it later, but they found it on January
8th.
Right, but or the 9th. But the point was that they observed on his cell phone that on the 5th, he went to his mom's and hung out by the dumpster.
I'm so confused how they didn't find anything in the basement on the 5th.
Well, maybe that's why there was still some trash bags in there.
Huh? There was shit all up in the basement. When did he take the trip to the depot? Was that on the 4th?
It was on the 1st and the 2nd.
He went to the depot that early?
I can't.
I forget too. So Schmidt briefed to Chico and Bukhenik on what had been done in the investigation thus far, and the 3 officers listened to the audio recording of Brian's interview on the prior evening. Thereafter, at 8 p.m. on the 5th, Schmidt, Lopes, Hunt, Chico, and Bukhenik went to the Walsh residence. When the officers arrived, Brian was at home with his 3 children and his mother, Diana Walsh. Walsh's nanny, Robin Howe, was leaving as they arrived. The interior layout of the Walsh's residence is the open floor concept with the dining room situated to the left, the entrance in the kitchen on the right. There's a large dining room table and window bench seating. Schmidt, DeCicco, and Hunt interviewed Brian at the dining room table. Lopes and Bukhenik interviewed Diana and Anna and Brian's 6-year-old son, TW, in the television living room, which is separated from the dining room area by the staircase. That's interesting. Brian's January 5th, 2023 interview was audio recorded and a transcript of the interview was prepped.
January 2nd, Home Depot, by the way.
Okay. That's when he bought all the shit. That's when they saw him with all the shit. I just don't get how they didn't what he had done, because they found so much of that shit in the basement. So much of it. It's weird. Okay, so, and there's a footnote, the audio recorded interview and transcript are in evidence, and both sides agree that they are a fair and accurate representation of the interview. Court has listened to the recording and reviewed the transcript, which the court concludes accurately reflects the content of the interview. Court will not detail the entire contents of the January 5 interview, but will refer to the contents as needed herein. During the interview, the children are heard in the background. In addition, female voice and male voices could also be heard in the background. Presumably, Diana and law enforcement officers interviewing her. None of the background noise is transcribed. So the interview lasted just under an hour. Throughout the interview, Brian is calm and cooperative and consistent with his interview on January 4th, repeatedly indicated that he wanted to cooperate with law enforcement's investigation to find his missing wife. Brian told Schmidt and DeCicco that he typically had daily contact with his wife, had no concerns about Anna committing S, and that neither spouse was involved in an extramarital affair. Incorrect, sir. Brian explained that the sources of Anna's stress-induced work, her physical distance from Brian and their children, and Brian's criminal matter in federal court. Brian reported that he did not argue with Anna on the morning of January 1. Well into the evening, DeCicco and Brian asked Brian if the police could download his phone specifically. All right, who do you want to be?
Trooper, I'll be Walsh.
Okay. So DeCicco, okay, well, I know you said you're willing to, do whatever you can to help the investigation. We thank you for that. And, part of what I think is trying to understand Anna. I think if you would allow us to look through your phone and consent to us downloading your phone and seeing some of the communications between you and her and like her tone, I believe you said in the interview that she said that she may have used your phone occasionally to send and receive stuff.
Yeah.
So I think it'll help us really create a permanent timeline of the events of the 1st and the 31st and the 1st, and maybe get a better insight into Anna. Is that something you'd be okay with?
So just to be clear, you want to download everything on my phone?
We will download with the extraction. We'll download all the contents of your phone. Yes.
Oh, that's a lot.
What we're focusing on, though, is what we're interested in. Yes, it downloads everything, but what we're interested in is locating Anna and finding the information specifically in there that would help us do that. The Anna specific content.
That's a huge amount of personal information, gentlemen.
It's a big ask. This is Schmidt. It's a big ask, but there's a lot on the line.
No, there is a lot on the line.
You know what I mean?
Mm-hmm.
DeCicco, what's your concern?
I don't know.
Is it your other legal issues?
That's one of them. I guess my request would be, I'm willing to do anything, but my only request would be because Tracy Minor called me today about what's going on.
Who's that? That's
Tracy Minor is who's representing me in my other legal issues.
Detective Schmidt again. Okay. Yep.
So she said, before you do anything like this, you have to talk to me. I want to do everything I can to support this 100%, but I got to call her about it.
Schmidt, she said before you do anything, like turn over the phone or anything?
No, before you do anything. I mean, because she always wants to be here to talk to law enforcement. I said, well, I'm going to talk to them and give them whatever they want. But I just have to ask her quickly about that. I'm sure it'll be fine. Or she might say, can we just do the information you're asking for?
Right. That's Schmidt. And then
Trooper,
DeChico. Well, that's all we'd be interested in. We'd be interested in your communication with Anna and the dates of, the 31st and the 1st through the present. We're not interested in your other past or your other issues.
no, I understand.
DeChico. And, that being said, I believe, we would, you're represented by counsel in that matter. I don't, I'm not a legal, despite being a police officer, I'm not a legal expert, but talk to your attorney. But I believe that would require a search warrant for that stuff to be used against you. That's not what we're looking for to even get into.
How long would it take for you to download it?
DeChico. It would take, once we hook it up to the machine, which is in Canton, it would take, depending on how many gigabytes of data it is it a lot or?
Yeah, like 128 or something.
Schmidt, it's a smaller one. DeChico. Then I don't know. It could be 30 minutes, 30 to an hour.
Okay, so an hour of time to Canton.
DeChico, yeah. Call it an hour to download. Yeah, I mean, I think it would be useful to our investigation. I think it would be
Okay.
helpful if you want to consent to it.
All right. Well, I want you to know that that is my intention.
Sure.
And my only request is to talk to Tracy and to let her know that's what I want to do, at least to give me what my risk exposure would be in life right now.
Schmidt, just so you're aware, if it's any peace of mind, like we don't have a crime. We're not investigating a crime. This is a missing person.
No,
this is
I understand.
We're out here of a community caretaking function.
No,
just so we're abundantly clear, like
I'm fully
okay.
No, I'm fully aware of that, and I appreciate it. And I know, and I want you to know that I'll be very quick with it. And if Tracy and I can talk in the morning, then what would be the process? I would just give you the phone, or I would come to Canton, or I need to be away. I do a lot of work on the phone as well.
Well, this is DeChico. Well, we could come get it, and we could probably actually potentially do it here. Yeah.
Oh, really? Okay.
DeChico, we have a portable device. We could just bring it here and do a download. There's a guy who works in my office. It does it really efficiently, and I can send him over.
Okay, great. So will you gentlemen honor my request to give me a moment to talk to Tracy about it?
DeChico, well, no one's taking your phone from you, indiscernible.
No. But I'm only interested in finding Anna. And
yeah,
don't care what it takes. But I just have to make sure that I listen to all the advice I have coming my way, which is a lot. I do apologize, but I most likely will be able to do that, and I'll be able to do it tomorrow. And that's my intention and my declaration.
Okay. So Brian emailed Minor the evening of the 5th, 2023, to tell her that the cops had requested his consent to search certain electronic devices. As of the January 5th interview, DeChico asked Brian to bring his children to a forensic interview the following morning at 10 a.m. Although Brian initially agreed to the forensic interviews of the children, he canceled the interviews the following morning. After the January 5th interview ended, Brian gave the officers permission to search his entire home, and the officers did so. The search included the attic, which had not been searched the prior day. Based on their experience, the officers knew that S victims had been located in crawl spaces in attic areas. Officers noted a hole in the drywall ceiling between the attic access and the Walsh's bedroom. Outside, officers again flashed lights into the pool and looked into the Volvo X90. Brian provided keys to the Volvo X90, and inside the vehicle's officers found a receipt from Lowe's and a cell phone. Brian stated the cell phone inside of the Volvo X90 belonged to his oldest son, TW. Schmidt observed vacuum marks on the interior carpeting of the vehicle and noted that the plastic sheeting that had been in the back area of the vehicle on January 4th was no longer there. Among the other items the officers were looking for on a cell phone but did not find it. Officers checked the outside trash bins but did not find the plastic sheeting or retrieve anything else. At the same time that Brian was being interviewed on the evening of the 5th, Sergeant Bukhenik and Lopes interviewed Diana Walsh and 6-year-old TW at the Walsh residence. This interview was not audio recorded, but due to the open concept floor plan, parts of it can be overheard on Brian's audio recorded interview that was taking place in the dining room. During her 15-minute interview, Diana stated she hired a top private investigator in DC to locate Anna, and she shared the contact information of that individual with police. Diana confirmed that Brian arrived at her Swampscott home on January 1st, 2023, without his phone, and that he asked to use her phone to contact Anna. After her interview, Diana was present for TW's interview, and he sat on her lap throughout. TW stated that he heard a noise in the early morning of January 1st, 2023. And when he came downstairs, he saw Anna laying on the couch underneath his blanket, which he left there overnight. Anna was wearing pink pajamas with red hearts. Oh, it's so sad. TW saw his iPad on the kitchen island and picked it up. TW realized the iPad wasn't working and handed it to Anna to fix it, and she did. And then Anna then went upstairs and came down wearing her real clothes, carrying a brown duffel and a purse. TW believed Anna's taxi was at the house. He told his mother that he loved her, and she responded, "I love you more." Oh. And she left. Bukhenik began to ask TW if he knew where his mother was, but before he could finish his question, Diana interrupted and began flailing her arms, interjected the words, "Your mother's cell phone, to replace your mother. So wait.
Right. She didn't want him saying to him, like, do you know where your mother is? Because they didn't want him to know his mom was missing.
Oh, yeah. So TW did not respond to Sergeant Bukhenik's intended question or Diana's replacement question. He stated that he wanted his mother to come down to Washington, his mother wanted to bring him down to Washington, D.C. He abruptly got up and ran to another part of the home. Schmidt and DeChico returned to the Cohasset Police Department at approximately 10:30 p.m. and continued efforts to find Anna, checking for recent bank activity. Also on the 5th, Keith examined exigent cell phone records received from Verizon and determined the last time Anna's phone contacted a cellular tower was 3:14 a.m. on January 2nd, 2023, and the device connected to a cell tower on Reservoir Road, Cohasset, approximately a quarter mile from the Walsh residence. January 6th, MSP brought in additional assets to conduct a larger scale search for Anna. Chief Quigley held a presser characterizing the case as a missing person investigation. Also on the 6th, Brian went to Attorney Minor's home to discuss the Chico's request to download and examine Brian's phone and other digital devices. Brian, and then there's a footy. Minor reached out to Brian on the afternoon of the 5th after learning that Anna was missing. Later on the 5th, Minor received an email from Brian saying that law enforcement wanted to download and examine Brian's phone and other digital devices. Brian, back to the body of the pleading or of the ruling. So Brian brought his cell phone and TW's iPad to Attorney Minor's home. Attorney Minor had concerns about turning over any devices to law enforcement for examination because, as she testified at the hearing, quote, "I don't like to give the government anything." Good lawyer.
Right.
Except she gave it to him. Attorney Minor explained to Brian what the Commonwealth wanted and explained his rights. And that's footy 6. Attorney Minor observed Brian listening to her and believes he understood what she said. Minor knew that law enforcement would perform a full data extraction, a mirror image of the device or of the devices Brian turned over. Minor testified that there was no ambiguity as to what law enforcement was looking for. However, Minor's present recollection and understanding of the agreement that she discussed and negotiated with law enforcement was that Brian would turn over his phone and his son's iPad, that the Commonwealth would only look at communications between Brian and another person for the period of December 25th through the 6th, excluding attorney-client communications. All right, pick it up. You got
Attorney
it up?
Minor reviewed Brian's phone and TW's iPad for several hours. During her review of Brian's phone, Attorney Minor identified a marital communication prior to December 25th, 2025 that she had some concern over. She found no text messages, emails, phone calls, or voicemails during her review of TW's iPad. In the 3 p.m. afternoon hours of January 6, 2023, Sergeant Bukhenik had several, likely 3, conversations with Attorney Minor regarding Brian's consent to the digital evidence extraction of certain electronic devices. At that time, Sergeant Bukhenik knew about 2 phones. Brian's phone that had been missing on January 1st, but located on the 2nd, and TW's phone found in the Volvo. Sergeant Bukhenik first told Attorney Minor that law enforcement wanted to do a full system extraction of the phones, more commonly known as a phone dump. Attorney Minor stated that she needed to talk to her client, and within a short time, she called him back and stated she would consent to the requested extraction with some limitation. Footnote 7, based on her concern regarding the pre-Christmas marital communication, Attorney Minor suggested Sergeant Bukhenik agreed to a date limitation of December 25th to January 6th. She also asked that the search exclude her attorney-client communications with Brian. Returning to the body, Attorney Minor wanted to document the verbal agreement. In addition to 2 cell phones, Sergeant Bukhenik asked for TW's iPad mini. Based on his interview with TW the prior evening, Sergeant Bukhenik knew that if Anna manipulated TW's iPad before she left the Walsh residence, there would be a digital imprint of same found on the iPad's extraction. He did not explain why he wanted TW's iPad to Attorney Minor. Once the agreement was struck, Attorney Minor explained it to Brian. Sergeant Bukhenik contemporaneously memorialized the agreement he reached with Attorney Minor in an investigative report, Exhibit 22, which is dated January 6th, with an approval date of January 13th. In his report, Sergeant Bukhenik specifically noted, "It was communicated to us during an early interview that Anna manipulated TW's iPad at TW's request prior to leaving their home on January 1st. It would have further narrowed down the timeline for investigators to focus on in the search of the missing victim." Am I missing a sentence here? Okay.
No, that's what it looks like
Right.
on mine too.
Following their conversation, Sergeant Bukhenik gave Attorney Minor contact information for 1st District Attorney Lynn Beeland, FADA Beeland, so that their agreement could be memorialized as required by Attorney Minor. Thereafter, Attorney Minor and Beeland exchanged 3 emails between 3:39 and 4:06. Sergeant Bukhenik was copied on 3 emails, which he attached to investigative report. After Minor and Beeland emailed regarding the terms of the extraction and examination. Footnote 9, after memorializing the agreement with Beeland, Attorney Minor advised her client about the terms of the agreement and told him it was his decision. Brian decided to turn over the device for extraction and analysis. Sergeant Bukhenik arranged for law enforcement to pick up the electronic devices from Brian at the Walsh residence. Because he was traveling to Washington, D.C. to further investigate Anna's disappearance, Sergeant Bukhenik asked Lieutenant Fanning to pick up the devices, 2 cell phones and 1 iPad. Footnote 10. Lieutenant Fanning believes Sergeant Bukhenik told him to pick up 1 cell phone and 1 iPad. After speaking with Sergeant Bukhenik, Lieutenant Fanning called Attorney Minor, and she told him that he could go to the Walsh residence to pick up the devices. To pick up the electronic devices. In this approximately 5-minute call, Lieutenant Fanning specifically raised the importance of TW's iPad to the ongoing investigation, namely that because Anna touched the device and fixed it for her son on January 1st, 2023. Go, babe.
What?
Just go again.
Determining the time that happened would narrow the search timeline that law enforcement could properly target in on the surveillance of vehicles coming and going from the Walsh residence. In the 4 p.m. hour, Fanning arrived at the Walsh residence to retrieve the electronic devices. Fanning believed he was to pick up 2 devices, Brian's phone and TW's iPad. After introducing himself to Brian and explaining he was there to pick up the electronic devices, Brian handed over his phone and TW's iPad to Lieutenant Fanning. Brian was very cooperative, cordial, and helpful. Lieutenant Fanning did not use a consent form because he was working cooperatively with Brian and Attorney Minor to obtain the devices and search them. Before he left, Brian told Fanning that he had another iPad that the children used and that he wanted to give it to him. Brian retrieved that device and handed it to Lieutenant Fanning. The second iPad had a cracked screen. Lieutenant Fanning confirmed the passwords for the devices with Brian before he left the home, and then he returned to his vehicle. Inside his car, Fanning confirmed the password were for Brian's phone The password worked for Brian's phone, worked and checked the last text communication between Anna and Brian. Fanning returned to the Cohasset Command Center and handed over the 3 devices to Keefe, the examiner, who in turn brought them to the Digital Forensics Lab of Norfolk County District Attorney's Office in Canton to perform the full data extraction and review. Fanning also gave Keefe a piece of paper with the passwords written on it and instructed him that he had consent to download and analyze the data on the devices from the 25th to present. Once he arrived in Canton, I mean, when you think of, once he arrived in Canton, Keefe met Trooper Nicholas Guarino. Keefe was told and understood that Brian and Attorney Minor provided consent to extract and analyze all data from 3 devices from the 25th through the 6th. Okay, and then there's a footy. The Great Key Cellubright software allows the examiner to segregate and analyze only communications in the timeline feature. However, based on his conversation with Fanning, Keefe understood that he was permitted to extract and analyze all data extracted in the agreed to time frame. Keefe understood that attorney-client protected communications in this case took place before December 25th, 2022. Now, like, does Brian Walsh like live in a fucking cave? Like, who would conduct all these searches on any device that you're handing over to the cops without the understanding that, number one, you cannot delete shit from your devices permanently? Like, they'll like Cellubright, Great Key, that shit gets like, it recovers like 90+% of it. You know, it's like, it's crazy to me that this guy, like, he had to have been thinking, man, I wonder if there's some kind of way that they're going to be able to find my like deleted searches and shit. You know, it's like, thankfully he's a fucking moron. I'm still sitting here thinking about how they didn't find anything in the basement on the 5th when they went down there. I'm so confused about that. Because Ali says that he's out in Mom's neck of the woods on the 5th. That's when he does the dumpster dump on the 5th. That's the one where they actually recovered the 10 bags of shit, which certainly had a lot of stuff that indicated that he had already done the deed in terms of like disposing of the body. Like, I don't get it. Like, how when they come back on the 8th and they effectuate the search warrant, how they find all the shit down there. You know, including blood and the hatchet and all that shit. It's weird. It's confusing to me. He then started the extraction of TW's iPad mini, and then he went home. So on the 7th, Schmidt gets the ransom email, which we've read already. Email contained no timeline, no demands, no contact instructions. So Keefe returns to the Digital Forensics Lab on the 7th at 10:30 a.m. He began the extraction of the cracked iPad. Keefe then loaded the data extracted from the 3 devices to the server, which was completed around 3 p.m. And that's Exhibit 15. And that is footnote 12. The event log time is reported in UTC, a coordinated universal time. The user must subtract 5 hours to convert the time to Eastern Standard Time. All information other than evidence ID here, Cohasset missing person, and the examiner name here, Trooper Keefe, are populated by the Great Key software. And then 13 says, pursuant to the consent agreement, Keefe and Guarino used the timeline view to restrict their search to the 25th through the 6th. Okay. Thereafter, at around 5 p.m., Keefe and Guarino, who arrived around 3 p.m., began reviewing the extracted data using the Cellubright physical analyzer, subject to the agreed-to limitations, namely date limited to between the 25th and the 6th of December and January, respectively, and excluding any attorney-client privilege communications. Keefe was in the first floor lab reviewing data from Brian's iPhone 13, and Guarino was in the second floor reviewing data from the TW's iPad 6 mini. Both troopers were using Cellubright to review the extracted data in the timeline view. In his review, Keith determined that Brian's phone had been unlocked 4 times in the January 1 to 2, 2023 time period. So like they know right there he's lying. At some point after he began his review, Keith received a call from DeChico. DeChico told Keith that he had interviewed Brian sometime earlier that day, and Brian that stated on the 2nd that he only had been to Press Juice Bar in Norwell. And DeChico asked Keith if he could confirm that information by looking at the native location data of Brian's iPhone 13 mini. Keith was able to determine that Brian's iPhone had been in the area of the Home Depot in Rockland at 4:12 on the January 2nd date. Guarino spent about an hour from 5 to 6 p.m. on the 7th of January, 2023, reviewing data in the timeline feature extracted from TW's iPad 6 mini. As he reviewed the data, Guarino first noticed searches on December 27, 2022, relating to the best and the worst states and places to get divorced. In the extracted data from the morning of January 1st, 2023, at approximately 4:55, observed searches on how to dispose of a body. So Guarino continues to review the data up to the January 2nd, 2023, and observed numerous searches on body disposal, removal of smell, Cohasset dump, and cadaver dogs at dump. At approximately 6:30 p.m., Guarino reports to Keith what he had found in terms of concerning searches while reviewing the data from TW's iPad 6 mini. Guarino also reported his findings by phone to Lieutenant Tully, who was in charge of Guarino's unit. Guarino then created a PDF from the searches, which he emailed to Tully and copied to Fanning, Bukhenik, DeChico, and Proctor, Exhibits 17 and 18. MSP decided that Guarino would stop his search of information extracted from TW's iPad mini and seek a search warrant for the device, which was now back at the Walsh residence. So earlier in the day at approximately 2 p.m., so they find all that shit. They tell him to stop. They're like, let's go get the warrant. Which probably in retrospect saved their ass. But maybe not. Maybe not. Hold on. I just saw something. What's Aaron trying to say? Something about Aaron Spencer. Or Brady. Contact Melanie Neal. She's looking for someone's friend. Contact Melanie Neal. She's looking. Yeah, we know. We're friends with Melanie. I mean, we're 100% all about Aaron Spencer. So there's just short of us going through the documents that have been filed, there's not much going on. He's got a date on the 8th. I'm working the back channels on that case hard. So we got Aaron Spencer's back. So the interview lasted approximately 2 hours. Brian's January 2023 interview was audio recorded and transcript, which accurately reflects the interview was prepared. All right, you want to take over?
Well, I kind of thought that we could skip down to, because a lot of this. Wait, where were we? Where are you? Page 18?
19.
19, because I was looking through it, and she just gets into
the weeds.
No, just like, going through like the exhibits of the different things. Talks about how Brian reminded, like that Attorney Minor was involved, that she'd interrupt Brian at certain times and reminded him not to discuss attorney-client privilege. He was explained the protocol that undertook the alert to alert federal authorities when he was leaving his home. It required 72 hours advance notice. And Attorney Minor had granted permission to review those emails. So she's going through like all the other things that Attorney Minor had granted them to review. So how can she now say it was limited just to, the text messages? He went over, she went over Brian's statements like she did before, that he said that Anna had used the chat function on the phone for the chat for the JetBlue, that Anna used the Uber apps, and would have used the phone to make the transportation arrangements. So basically, when they get down to it, as to what exactly why the judge is finding that this is, go down to rulings of law on page 22.
Okay. At the bottom of 22.
No, I was just wanted to see.
Oh, here we go.
Right. So the court gives, the basis for voluntariness of a search, that it has to be a free and voluntary consent, can't be coerced in any way. The scope, they have to say what their objective is, all of that stuff. So turning here, and that's in the middle of 23, the defendant first challenges the voluntariness of his consent to the search of certain electronic devices, largely within his motion. He argues the police misled him by telling him they were investigating a missing person in the context of the police community caretaking function, when in fact they were targeting the defendant. The Commonwealth counters that it was abundantly clear that the investigators intended to verify Brian's whereabouts as part of their investigation, citing the defendant's third recorded interview with police, in which police told Brian they intended to develop a timeline of his whereabouts because of public suspicion. Brian's responsive acknowledgement that his attorney had already prepared him for that, and attorney Minor's comment to police, "Thank God for the ankle bracelet," as it would have his location data for January 1st to the 2nd, 2023.
Where are you?
The bottom of 2023.
Of page 23?
I'm sorry,
Oh,
page 23.
okay. All right.
Viewing the circumstances of this case in their totality, and after careful review of 4 recorded interviews, this court concludes that the Commonwealth has met its burden by demonstrating the defendant's consent was voluntary. Then they cite some cases that talk about mental anguish and use of drugs, things that could make something involuntary. The court here finds there was no evidence of coercion. The defendant not only repeatedly indicated his intention to do whatever was needed to assist the police in finding Anna, but he was given time to consult with his attorney and thereafter turned over his cell phone and 2 iPads. Because he turned over the devices, Attorney Minor explained his rights to him, which evidences knowledge of his right to refuse consent. While Brian may have been upset that Anna was missing, tired from police questioning, and at times distracted by his young children, these factors did not invalidate his consent. In addition, there was no trickery employed by law enforcement, as here, I think there was a little bit, but Trooper DeChico stated to Brian in his third recording interview, ironing out a reliable timeline for Brian would help the police address any public suspicion and benefit both Brian and the police. So that's sort of more that DeChico said, in contrary to what I don't remember which officer said, "Oh, well, I think we need a warrant for that, to use that stuff against you." But and then the court cites a U.S. Supreme Court case that consent not rendered invalid when the police do not disclose everything they might have in mind in seeking. Next, the defendant challenges the scope of the search, arguing the Commonwealth exceeded the parties' agreement. This was the big one here, as to what actually be reviewed. Specifically, the defendant argues that while he consented to and knew that law enforcement would do a full data extraction of the 3 devices, the agreement he entered into with the Norfolk County District Attorney's Office would allow law enforcement only to look at communications between Brian and other people, excluding communications with Attorney Minor in the period between December 21st and December 6th of 2023. Footnote 19 says there is no dispute that the parties agreed to a search time frame of December 25th to January 6th. The Commonwealth counters that it did not exceed the agreed to consent and that the parties' agreement did not restrict it to looking only at communications between the defendant and other people. Rather, according to the Commonwealth, the only exclusion from the search in the agreed to time frame was communications between attorney minor and the defendant. As noted, the court's inquiry as to what the typical reasonable person would have understood by the exchange between the officers and the consent giver based on the totality of the circumstances. Viewing the entire exchange between Detective Schmidt and Trooper DeChico with Brian on January 5th, and that between Sergeant Bukhenik and attorney minor on January 6th, a reasonable person would have understood that the search as including all data extracted in the date range of December 25th, 2022 to January 6th, 2023, excluding only attorney-client communications between Brian and attorney minor. The first interview that took place where officers requested Brian's consent to search his phone occurred on January 5th between DeChico and Schmidt and Brian. Trooper DeChico made it clear that the officers were asking for consent to download the entire phone. Although he stated that police were interested in seeing the communications between Anna and Brian, Trooper DeChico explained that the police were interested in locating Anna and finding the information specifically in the phone that would help them to do that, the Anna-specific content. Brian's acknowledgement of the huge amount of personal information they were requesting signaled to police that he understood the breadth of the information they were seeking. Sergeant Bukhenik spoke to attorney minor about the request for consent to a digital extraction multiple times on January 6th. He also made it clear that law enforcement wanted to do a full system extraction of the phones. Attorney minor suggested, and Sergeant Bukhenik agreed, that the search would be limited to December 25th to January 6th and would exclude her attorney-client communications with Brian. To the extent attorney minor intended the search to also be limited to only Brian's communication with others in that time period, she did not directly or indirectly communicate that to Sergeant Bukhenik by stating as much or inquiring as to whether police could extract only communications rather than the entire phone contents. She further agreed that Brian would also turn over TW's iPad, a device which she knew did not contain any communications between Brian and others. So that's a good point that the court's making there. We talked about that earlier with regard to the emails. Well, you were letting them search other things. So how can you say it's only limited to attorney to text communications and conversations? During police interviews, troopers made repeated reference to their interest in and their timeline importance of determining when Anna fixed TW's iPad in the morning of January 1st, 2023, and that there was a clear indication that they desired to look for information to pinpoint the exact time that happened. Trooper Fanning expressed the same sentiment to attorney minor during his phone call with her about picking up the devices. She did not inquire as to whether police could extract only communications rather than the entire phone contents, and neither she nor Brian ever questioned why the police were requesting consent to search TW's iPad when that device did not contain any communication between Brian and others, although they told him it was to determine what time she fixed the phone. So if it was indeed their understanding that police only sought communications, there would have been no need to turn over the iPad at all. Moreover, given that attorney minor stated that she did not like to give the government anything, it would make little sense that she would agree to turn over 2 iPads that contained no communication if, in fact, the scope of that consent was limited to only communications. She cites a Massachusetts 2010 case for the proposition that police justified in believing there was no limitation on consent to search entire home based on consent givers' words and actions. That sort of rose into a good faith argument that they were relying in good faith on what they believed was consent to search all of the devices. Additionally, Brian repeatedly expressed his intention to assist in the missing person investigation in any way possible, offering up his cell phone during the interviews for police to view and voluntarily handing over other cracked screen iPads used by the kids. Now, he did say all my text messages for years, if looking at those would do anything. So I think there was some limitations there. Moving on, applying a common sense interpretation to the exchange between the officers and Brian and between Attorney Minor and Sergeant Bukhenik, it was objectively reasonable to conclude that the consent to search included all data on the 3 devices that could be extracted to assist in finding Anna, as that was their primary focus in the then missing persons investigation. And they cite Ortiz, a Massachusetts case, 2 Massachusetts cases, Fencher for court applying a common sense interpretation to the entire exchange between defendant and police detectives found it is objectively reasonable to conclude the defendant's consent to search her cell phone was free, voluntary, and unlimited. I wonder, I see some issues with the judge's logic here, to tell you the truth. Like, this is a good faith argument. This is what she's making here. I don't know if this would stand up on appeal or not, or how it would stand up.
Well, I mean, I think that they're going to file an interlocutory appeal.
I don't think they can file an interlocutory appeal.
Why?
I think we looked into this before, that you can't file the defense can't file an interlocutory appeal. Not for suppression of evidence in Massachusetts.
Oh, really?
No. The defendant argues that Attorney Minor negotiated the scope of the search with Beeland, and that their agreement only concerned communication on the devices. However, Beeland merely memorialized the already agreed to terms of the consent agreement between Bukhenik and Minor. Beeland's email noted that any conversations between attorney and client Brian Walsh and any conversation between Brian Walsh and his wife Anna on the week before she went missing, 12/25 and prior, shall be excluded from the search and examination of Brian Walsh's phone and TW's iPad. Attorney Minor responded, "We consent to all communications on or after 12/25. If you want to go back further than that, I will have to get you a list of attorneys, as he has used a bunch of them." I mean, we consent to all communications, not anything else. I don't know. Nothing in this exchange limits the search and examination of the iPhone and iPads to only communication. Rather, the emails refer to the exclusion of communication subject to attorney, client, or marital privilege, material that typically would be excluded from the search of a device capable of containing such communications, given the content of the email exchange, noting only what should be excluded from the search of the iPhone and the iPad, along with the previous discussions about the extraction of all data. A typical and reasonable person would not have understood the emails to be limited to the search to just communications. That's not the questions, what they thought it was. It's what did the defendant consent to?
Right.
The defendant also contends that at the very least, the scope of the agreement. Well, here we go. Right here, she gets into it.
No,
the defendant,
throat. Like, are you having a throat issue?
I don't know. I had like a tickle, and
Do you want me to finish it?
sure.
I mean, you can.
No. Go ahead. Start at the defendant
It just
also.
seems like your throat's bothering you some. The defendant also contends that at the very least the scope of the agreement was ambiguous, and that the ambiguity should weigh in favor of the defendant and against the Commonwealth. It is certainly true that, quote, the requirement of reasonable clarity, end quote, applies to the scope of consent, and that if the court is unable to discern the scope of consent because the agreement was ambiguous, then the search should be deemed unlawful. See Ortiz. However, the scope of consent in this case was not ambiguous. The police explained in no uncertain terms that they were performing a full data extraction of the devices and looking for information to assist in locating Anna. They explained their intent to create a timeline using data showing the last time Anna manipulated TW's iPad. The discussions about limiting their search only concerned communications subject to attorney-client privilege, and those between Brian and Anna before December 25th, 2022. And the actions of the police, Brian and the attorney Minor, reflect an agreement to consent to a search of the phone and the iPads for any information in the agreed-upon time frame that could assist with locating Anna, excluding only the aforementioned communications. If attorney Minor believed that she was consenting to a search of only only of communications in the devices. The court's inquiry here is to what, quote, a typical reasonable person would understand the scope of the consent to be based on a, quote, a totality of the circumstances. Based on the overall context of the encounters with the police in this case, an objective observer would not perceive the search as exceeding the scope of the defendant's consent. What do you think that is?
What do I think? What is?
Yeah, I mean, we read through the conversation. Do you think that the scope was clear?
No, I think that I think they made it clear that they intended to do a full extraction. And then the defense is arguing that they were going to do a full extraction. They agreed to only look at, I don't know that it's a great argument, that they agreed to only look at communications, which is why the judge says, well, then why wasn't there a question? Can't you only, I mean, like an experienced lawyer is going to know, well, why don't you just extract communications?
Yeah.
But I also don't think saying we're going to use this iPad to determine the last time that she manipulated it was a consent to search the search history of the phone, of the iPad. But it also does, the court has a good point that you don't turn over an iPad that doesn't have text communications on it and say, go ahead and look for text communications.
Right. What else are you looking for on an iPad? Apps and Google searches. I mean, that's all you can do on that thing. If you're 6, right? I mean, you're not.
But now they've got some backup here with inevitable discovery. So let's see where the court goes with that.
So even if the Commonwealth exceeded the scope of the agreed to search of the electronic devices, the exclusion of the evidence obtained is not automatic. Evidence need not be excluded under the fruit of the poisonous tree doctrine, even if the government misconduct was a cause, in fact, of the discovery of the evidence, if the government obtained the evidence through an independent source. If the connection between the improper conduct and the derivative evidence has become so attenuated as to dissipate the taint, or if the government can demonstrate that the evidence inevitably would have been discovered by lawful means. That comes from Commonwealth v. McAfee, quoting Commonwealth v. Fredette. Internal citation, I don't need to read that. In this case, the challenge searches and location data would have been inevitably discovered during the execution of the search warrant at 516 Chief Justice Cushing Highway, during which law enforcement would have seized the defendant's cell phone, TW's iPad, and the other electronic devices. I don't know about that.
Well, she's going to have to touch out that there would have been enough evidence with his inconsistent statements, with the fact that there was no evidence that she
For
left.
A search warrant of the house?
It's the last place. Well, let's see if she gets to it.
He had already consented to a search. They had already searched the house. They had gone into the basement. They'd searched the whole house. And the only place they didn't find anything on a consent search.
Right. Well, let's see if she gets into why there was enough evidence to get that without the search history.
Okay, so the inevitable discovery rule under Article 14 requires a 2-step analysis, which focus first on the question of inevitability and second on the character of the police misconduct. Again, citing McAfee. Quote, the Commonwealth has a burden of proving the facts beyond inevitability by a preponderance of the evidence. And once the relevant facts have been proved, that discovery by lawful means was certain as a practical matter, quoting Perot. The severity of the constitutional violation is critical in deciding whether to admit evidence that is shown would have inevitably been discovered. Citing McAfee, again, quoting Commonwealth v. O'Connor, bad faith of the police shown by such activities as conducting an unlawful search in order to accelerate discovery of the evidence will be relevant in assessing the severity of any constitutional violation. Citing McAfee here, even assuming the police exceeded.
So this is the important information if anybody is not paying attention earlier.
Yeah. So here, even assuming that the police exceeded the scope of the consensual search after striking the references to the internet searches and location data discovered during the search of the full extraction of the 2 devices, the information remaining in the search warrant affidavit provided probable cause to believe that the defendant misled the police in its investigation into Anna's disappearance, and that the electronic devices that contained evidence of same would be found in the Walsh residence. This includes Brian's false statements about his whereabouts on January 1st. That's 2023, and TW's account of when Anna last touched his iPad and left the home. So Brian's account, so that's what she's hanging her hat on. Like that statement that by TW that his mom fixed his iPad.
Yeah, but that's makes no sense because that's coincides with what Brian said.
I know. Brian's account of why he did not contact police to report Anna missing and his subsequent communications to Anna and others about her disappearance when he found his phone, at paragraph 15, and information concerning the return of Brian's iPhone and TW's iPad to the home on January 7th of 2023. The terms of the warrant would have authorized police to search for electronic devices in the home, particularly those known to be manipulated by Anna and used by the defendant. Thus, discovery of the electronic searches and location data was certain as a practical matter.
That's a very weak argument. She didn't even put in any of the fact that Anna hadn't left the home. Well, I guess they wouldn't have had. They wouldn't have had.
Plus they had this statement from TW that he saw his mom get dressed and leave the house.
I don't know how that's helpful. How she's citing that as something that's helpful.
Well, she's not citing that. I'm saying in the opposite of that.
She does. She says TW's account of when Anna last touched his iPad and left the house.
Yeah, that's like, how does she find that helpful? It seems to corroborate Walsh's story that she got dressed, gave him a kiss.
I do agree that they can make this argument anyway. This next one, that the severity of the constitutional violation, presuming for the purposes of this analysis that the government's examination exceeded the scope, the consent given, there's no indication that the police acted in bad faith to accelerate the discovery of evidence through an unconstitutional shortcut. Because both prongs of the inevitable discovery rule are satisfied, there is no reason to suppress the search or the location data. So that's to say, all right, I think that they fairly, that they did not clearly understand that Attorney Minor was saying, no, you can only search this.
Yeah. I don't know. Next, turning to the severity of the constitutional violation, again, presuming for purposes of this analysis that the government's examination exceeded the consent given, quote, there is no indication the police acted in bad faith to accelerate discovery of the evidence through an unconstitutional shortcut.
So now you've got to take this and decide whether or not he accepts a plea. I'd be like, can we have a stipulated trial, which a lot of times in a murder case, they will not. Something so that he preserves his right to appeal this issue. Like, it sucks to have to go through trial just to appeal, just to preserve the right to appeal this ruling.
Yeah.
And, one way you could shortcut it is be like, we want to go to a stipulated trial where the state says, this is what we would put into evidence. And the defendant doesn't, challenge anything, just so that they can, appeal this ruling. So it's going to be interesting because you have to bear in mind, if they think that if they decide that this is the wrong ruling and that they could win on appeal, then he's not going to take a plea.
I know. I mean, it's
not unless they allow him to preserve his right to appeal this, and they're not going to want to have a plea where he's.
It's a tenuous argument on her part. It really is. I mean, when you kind of look back at, what she says would have been enough for a warrant for the house. I don't know if I agree, because of the fact that they were in there and they conducted a consent search of the entire house, but for the attic.
Right.
So Music to My Soul says Melanie looked it up and they would qualify for interlocutory appeal on this motion.
Oh, really?
Yeah.
All right.
I guess you just want to shut me down. I didn't look up shit. So
I thought that we looked it up earlier with Karen Reed, and that there was
All right. So because both prongs of the inevitable discovery rule are satisfied, there is no reason to suppress the searches or the location data. So order denied. And that was the big one. That was the big one. I mean, maybe I guess in the eyes of the judge, but again, I mean, judges bend over backwards to
Oh,
not.
yeah, they can appeal orders determining motions to suppress evidence.
There you go. So, I mean, I'm assuming that they're going to do that. And,
Oh, you
and
can't do
again,
that in Illinois.
what I was telling you earlier that you were kind of dismissing offhand was that I think that they've filed motions requesting other information about these cops because I think they're going to try to bolster their motion to reconsider with information if that's granted, if they can get that shit. Because I mean, I think in terms of attacking the credibility, because I mean, she's essentially saying, we've got recordings, we've got a recording of this one interview between the cops and Walsh, and then everything else is basically from memory, short of Bukhenik's memorialized email or whatever the fuck he wrote.
Yeah.
So, and that's it.
So
And
here's what Rule 15 says. A defendant or the Commonwealth shall have the right and opportunity to apply to a single justice of the Supreme Judicial Court in the form and manner prescribed by a standing order of that court for leave to appeal an order determining a motion to suppress evidence prior to trial. If the single justice determines that the administration of justice would be facilitated, the justice may grant that leave and may hear the appeal or may order it to a full Supreme Judicial Court or to the appeals court for determination. So I take it back. I'm sorry I shut you down. And in Massachusetts, a defendant can appeal a motion to suppress.
So Jody, these are the rulings by the judge. They're not, he may have just gone through the motions. I don't know if Peter went through the rulings because he's been in Greece on vacation. So he may have started with the motions. I don't know. I didn't watch it. But these are the rulings. If he was going through motions, these are not that. So there were two motions. We covered both of them tonight. So we covered both rulings on both. The one with the searches is denied, and the other one was allowed in part and denied in part. So we've gone through all of it.
Jody also asked us what we would have advised our client and how would you have handled this? We would have never allowed them to.
I don't even know what you're blowing air for. We never would allowed for, like, if she thinks they had enough to get a warrant after that consent search, I mean, good luck, because that would be, I mean, that's going to be ripe for, to me, some kind of Frank's hearing potentially, if they're going to go in and not admit when they're applying for that search warrant for the house that they did a full consent search of the house.
Yeah, maybe we would have said something like, we'll send it to a defense expert and they can give you a report of when the repair was manipulated on the iPad.
Yeah,
that was really the only important thing that they would have told them. And then maybe we did an extraction related to Uber.
Right, I mean, you've got the one cop saying that we're not investigating a crime here. This is a community caretaking function where, we're trying to find a missing person. That's it. You know what I mean? So it's like he's on record as saying that. And like from the defense side of this, we don't give a shit what the cops are thinking. Like if Allison's thing, like, oh, we'll send it to our own expert and we'll get the information you need and we'll pass it on, like sends up a red flag for the cops, too fucking bad.
Right.
Too, like we don't care about that.
We just blame ourselves. Look, I don't care. My guy wants to do it so bad. But I'm not allowing it.
Right.
That's how
we're overly cautious.
Right.
Because you guys lie, cheat, and steal all the time. So like, we just don't trust you. So, well, yeah, it's interesting. I mean, at this point, like, I think Allison brought up the most interesting point, which is really, short of them filing the interlocutory appeal, which I can't see them not doing.
No, you're right. They're definitely going to do that. I would assume.
Yeah, they're definitely, like, I can't in a million years not see them trying to appeal this. So, we'll see how that goes. But I mean, as it stands now, it's a win for the prosecution. It's a win for the cops.
They've got 30 days from the date of that order.
Yeah. Yeah. So, it's interesting. We'll see. So are you still completely done with this case? I think there's still some shit going on here.
Yeah, no, I'll keep following this issue.
Yeah. All right. So we got a few supers. Sky Goddess, thank you for your generosity. Love you all. Love you back. Hissy Fits. Family hug. And I saw some people asking for family hugs. Family hugs to all of you. We love you so much. Pammy, thank you for your super generous $25 cash app. Appreciate that very, very much. Tomorrow we're going to do something. I'm not sure what yet. I'm going to try to figure something out.
A lot of people are asking for us to go over Koberger.
I did a poll, babe.
Records. Oh, you did? And what did the poll say?
So 662 votes. So my question was, do y'all have an interest in us continuing to cover Koberger case, going through law, like it cut off the end of it, law enforcement reports. So like a lot of people are out there doing that.
What do people say?
It's 49% yes, 51% no.
All right. So we'll keep thinking. We were not going to, but a lot of you have asked us to. So
I mean, to me, that
thinking
feels like an
about it.
actual grift. Like just the guy has admitted his guilt.
Right. And I don't suspect there's anything in those police reports that we don't already know.
Well, I mean, you're going to be able to parse them and find issues with the investigation because you can find issues with every single investigation ever done by any cop anywhere. There's no such thing as a perfect investigation. And it's like,
all right, I got to hop off.
All right. The reason
bye guys. Love you all.
I am concerned about doing that is like the chat gets weird. It's like, I like no one is convincing me that guy's not a horrific murderer because I believe that he is. He's admitted as such. I don't think that there's anything there. If you're one of those people that thinks maybe he didn't do it, that's your prerogative. I'll never agree with you. And that's that. I mean, like on our channel, it's not going to be going through the document. I mean, to me, it just seems gratuitous, to be honest with you. Like I've handled these cases, like cases that are hyper violent and just devastating. And like, I don't feel the need to be like reading through the gruesome shit. I just don't. I get that some people like that, because like other creators are just milking the shit out of this thing with the Koberger stuff, and to me, it's fait accompli. It's over. I mean, that's where I'm at with it. But, I mean, we care about what you guys want. And we certainly want our subs and, people that are watching this channel to be happy. So, yeah, I mean, but Lana's like, she's got this thing where she thinks he didn't do it. So it's like, that's crazy to me. Like I'd be taking a very different slant. But we'll see. So at any rate, so that's it for Walsh. We're definitely going to be keeping an eye on this one. Aaron Spencer, I'm dying to get into that some more. Another thing that I'm working diligently on is I'm bringing back another episode of Bart. And if you guys haven't watched our first one on Barton McNeil, he's currently incarcerated, has been for 20 plus years. And we are of the mindset that he is wrongfully convicted. I'm working with his cousin who's supplying me with all kinds of stuff and has been. And it's, well, if she doesn't, she's changed her tune. She definitely did early on. So, I mean, she spent hours and hours and hours and hours putting together videos and trying to show that this guy didn't do it. And it was like, it was a hard sell for me, but But Aaron Spencer is very much a case. I'm going to be boots on the ground for that case. There's no question about it. There's no streaming in Arkansas that we know of. So I'm going to be going to court hearings. If it's a status call, I know there's something up on the 8th down there. Allie and I are going to be in New Orleans. It's only a 5.5 hour drive. I think that I will probably pass on that. I've actually sent word out to Aaron's attorneys to see if they'll give me a heads up and they can tell me exactly what that hearing is going to be. So I'm all about that case. That's an important case to me, and he deserves to have light shined on it, and no one's going to shine more light on it than me. No one. I'm going to see to it that that doesn't happen, because that's how deeply I feel that man should not be going to prison for what he did to save his daughter. So that's one that I'm going to be 100% fighting to the death on that, and getting as much information as humanly possible out about that case. And, you guys will be along for the ride. I'll give you everything I know you guys will know, presuming that I can talk about it. There's already shit that I know that I can't talk about at this point, but remember, tomorrow we'll figure something out. I'll see what's good. We'll do something that's interesting. But Wednesday night, 6 p.m. right here. And Mandy, get me that thumbnail so I can promote. Wednesday night, 6 p.m. Bob Alessi is going to be here in person, live and in person, for what I anticipate will be an amazing interview. I'm really looking forward to it. It's going to be a lot of fun. And Bob's fascinating in a lot of different ways. So make sure you mark your calendars. If you're not subbed, give us a sub. Make sure you like this on the way out. Help us in the algorithm. Like, share, subscribe. You guys know what to do. If you're on Replay Crew, leave a comment. Start a chat. Get it going. It's going to be great. And then David's coming on too, but he's on vacation this week, family vacation. And then he's got a 1-day trial, I think on August 3rd, not related to anything that we cover. And then we're going to have him on probably that week. So I'm looking forward to both those interviews. They'll be great. One other thing I want to pre-warn you and give you a heads up on. It's a little bit down the road, but I've been able to secure Amanda Knox. Amanda Knox is going to be joining us. If you don't know anything about Amanda Knox and her case, look into it. It's going to be an amazing interview, and I'm excited about it. That's going to be September 15th. So, you all check into Amanda's case. I'll probably do a couple primers leading into it. And I'm actually going to be reading her book. So I'm really, really excited to have Amanda on. She is definitely an exoneree. So that will be a super excellent live. So we got some cool stuff coming up. I'm always working, always trying to secure some great interviews with interesting people. And if there's anybody that you guys would like to see us interview, just let me know. I've got a pretty long reach. I could pretty much get to anybody, short of like just straight up like movie stars and shit like that. Anybody kind of in the true crime realm, I can get to and probably get them on the show. So, leave something in the community comments, and, that'll be something that we will work on diligently to make you all happy. So, all right. We love you guys because without you, I am literally just an old man screaming into the void. You know what I mean? So thanks, folks. I love yous. Bye.